So for this week, these are going to be the topics which we are discussing. You can see here. This covers from 10 February to 16 February, right? So Right to Information Act, in what context we'll see all the things about RTI. Then Right of Forest Dwellers in India, we'll see about FRE Act. Then the concept of load test and other related things we'll see. The issue of preamble, MSP demand, Water Act, we will see the recent amendment bill was introduced and it got approval in both houses of parliament. We'll see what is it, what are the changes that were being made now. And we have this HAPS, okay. So India is demonstrating this technology also. We'll see what is the benefit of this, and next UAPA. Then these are important from prelims perspective. So that is CMS bond convention is there. For this there is a COP that is happening in the recent time. So next we have one government scheme, PM-SVANidhi. This is in news. Section 125 of CRPC, Biodiversity Heritage Site, Retail Inflation, Kalsa-Bhanduri Project and other related issues. Supreme Court Collegium and Swami, Dayanand, Saraswati, the person in news, and also we have another program, Pradhan Surya, Ghar, and you have Muft, Bijli, Yojana. So these are the topics which we are going to discuss, okay. These are important from mains perspective and these from the prelims perspective. Let's start with the first issue, that is Right to Information Act. You know why it is in news? Electoral bonds, right? So when Supreme Court has quashed or made it unconstitutional, the scheme of electoral bonds, the main reason it stated is it is violating the right to information, which is implicitly there under Article 19(1)(a) of Indian Constitution. So you know electoral bonds means, again, what are electoral bonds? What are electoral bonds? Bond means what? In case if a question is asked in mains, suppose for example in 2 days if you have mains exam and this same question was asked in GS2, then how would you define electoral bond, or what is the introduction you will write? Money bearing instrument purchased for providing political funding by any individual, organization, anything established in the territory of India, especially these are interest free bonds, right? So you have to give the features, like in case if they are asking what is a scheme in detail, if they ask, give all the details. Otherwise, if they say the statement that electoral bonds is a violation of right to information, or in case if it is making the political funding opaque, or these type of statements if it is asked, just introduce in a brief and then go to the main issue. How it is asked also is very important, okay. So then you have to define. So here you know what is electoral bonds. It is a means of political funding. You know Supreme Court has made this unconstitutional because the persons who are electing the representatives, they also have right to information in respect of whom they are electing, how they are getting elected, what is the funding they are getting from the political parties, or like through the political parties from different persons or organizations. That is also implicitly there under right to know. That is what Supreme Court has opined, the main reason. And some other reasons were also stated, that is subsequent reasons, like financial quid pro quo is there, means gain for gain, you can say, okay. That means if I give you funding, later you give me some benefit. That is what Supreme Court has observed. This is what's seen in the political funding, right? Okay. So in this context, we are going to discuss about right to information. You might have come across electoral bonds. So if you have any doubt, you can ask me with respect to electoral bond. But here we are going to discuss specifically about Right to Information Act in this context, right? So you know this act was brought in 2005, okay, because earlier also so many proposals were made and so many, like you can say, large scale hesitations were also done by some organizations to make this as a fundamental right, right? If you have remembered, first country to implement this is in Sweden. Sweden in 1766 itself, it has made right to know as a basic right in their country. But you know, when we have our human rights, when did we have this codification of human rights? Have you remembered this? UN Declaration on Human Rights, that happened on 10th December, no? 1948. Human Rights Day we watch as this 10th December in the international level, right? On that day, first time we have codified and we have given these are some basic human rights that has to be given to all the citizens in every country by virtue of being born as a human. Everyone is entitled to these fundamental human rights. That is what given by the UN for the first time. But you can see Sweden itself in 1766 only it has given first time right to know. That is the origin you have to know. But in India, so the demand is there from 1960s. We have later on in 1990s, VP Singh is the Prime Minister, and at that time also he tried and he said there is a very much important need to introduce such a law which is providing right to information. And before this act we also have Freedom of Information Act which was introduced in the Parliament, but it could not get approval in the Parliament. Okay, later on subsequently we have this 2005 Act which was brought in the form of Right to Information Act. Okay, so right to information, although we are having this as a statute, but still it is implicitly there under Article 19(1)(a) of Indian Constitution, where we have fundamental freedom of speech and expression, right? Okay, that means this is a basic fundamental right which is already implicitly there. So in this context you should know what is the purpose of the act, what are the features of the act, and also what are the challenges. Okay, so if you know what is the thing that was introduced by this act, right to information, who can seek the information? Who can seek the information? Right to information means who can seek that information first? Very good. Any citizen of India, not foreigners. Okay, only citizen of India can seek information from whom again? From whom you can seek the information? Yes, but that is a proper word you have to use is public authority. Okay, from any public authority, any citizen of India can seek the information or they can exercise this right to information. So again, who are public authorities also defined under the act. So you need not remember sections. As you are not law students, you need not remember sections, but just understand the essence or the features of the act. So they have given public authority means any body or organization established under Constitution of India or by Parliament or state assemblies or through executive resolutions also. So in that way means anything which is related to government and its functioning can become a public authority. So from any public authority, any citizen of India can seek the information. But another important thing you have to keep in mind is there is some exception also given. I'll discuss that exception later. But coming to this, whenever you are asking the information, it should be disclosed to you from the designated authority within 30 days of your application. Okay, normally in normal situations 30 days your information has to be provided, but in case if there is any urgency or if there is a threat to the life of the liberty of the person, for example if that person is going to die but that information is very important to save that person's life, at that point of time within 48 hours also that information has to be provided. That is one of the feature of this particular act. In normal situations 30 days, but in emergency situations within 48 hours also. In case if you can show that there is a threat to that life and liberty of the person, 48 hours. But in case if you file a wrong application to the wrong authority, that means who have concerned authority, not going with that authority, if you have filed an application to some other authority who is not having authority to issue that information, then 5 days time period will be extended. That means 30 plus 5, 48 plus 5, 48 hours plus 5 days will be given. Okay, that means they have to change the authority, they have to send in again, they will send. In that way the time period is mentioned. In case if time period is not fulfilled or the persons are not giving the information within the timeline, then what should be done? You can appeal at the higher authority. Then in that situation also if it doesn't happen, what you can do? Information Commission. You have to approach state and central information commissions. You have two statutory bodies, no? These are statutory bodies because they are established under Right to Information Act. They are not established under Constitution of India. So when you are writing about statutory bodies which are under GS2, governance, there is role of statutory, quasi-judicial, and you have these bodies, no? So there you can write even CIC and SIC, okay, State Information Commission and these. So if you have to remember, there is a Central Information Commission mainly to take care about the Right to Information Act at the central level, okay. There is one composition is, it should not, one CIC will be there, Chief Information Commission, but not more than 10 Information Commissioners at the central level, okay, 1 plus 10, not more than 10. and the state level also the same, but there is no separate state act. Remember, under this act only they also have their origins. Do remember this, okay? Then another important provision is, in the recent times there is some amendment made to this act of 2005, Right to Information Act. In 2019 they brought an amendment strengthening RTI or weakening RTI. Weakening. Why? Yes. So previously CIC, that means Chief Information Commissioner and other commissioners, they used to have a tenure of 5 years, fixed tenure, okay? But now with this amendment, they are changed to the whims and fancies of the central government. Means anytime central government can appoint them and remove them. There is no fixed time period. Means they are more vulnerable now to the central government's whims and fancies. That is one main change that they have made. And with another change they have made is with respect to salaries, allowances also. Previously they have the same allowances like Chief Election Commissioner of India. CIC will have equivalent to CEC, and other information commissioners to the election commissioners they will have. But now again they have changed again that provision also to the wish and fancies of the central government only. That means if they have lost their autonomy or independence, okay, in this way with the recent amendment. In this way, this is one recent amendment which you have to quote. And another thing is, under section 8 clause 1 and 8 clause 2, there are some exemptions. I told you, any public authority, if you have to file an application, they have to give information, right? But not all authorities are entitled to give this information. There are some exemptions. For example, some sensitive information like defense or anything which is related to national security or RBI related information which is very important, okay? These type of informations can be exempted from not giving this right to information from these authorities. That is given under section 8 clause 1 of this act. Then section 8 clause 2 is there, which is giving exemption to those which are mentioned under Official Secrets Act. You have Official Secrets Act which is brought in 1823 by the British. That means some official secrets can be kept secret only. There is no mandate that they have to be disclosed. So under section 8 clause 2, whatever are mentioned under Official Secrets Act, those can be exempted by not disclosing under this Right to Information Act. That is also one exemption. Means it is not absolute. There are some exemptions even there under Right to Information. Second thing, recently if you have seen, most of the times like you can see the controversies with respect to right to information and also right to privacy. Yes or no? So right to privacy is making everything more transparent and accountable, right? But on the other hand, if you are asking every sensitive information, or sometimes some concerns are there that right to information is violating our right to privacy, because in the recent times right to privacy was also made as a fundamental right by Supreme Court, right? Under which article? 21 of Indian Constitution, no? Right to life and personal liberty. So here these two are getting in contradiction, you can see. So this is one issue you have to focus on, okay? That means this should not violate right to privacy because both are implicitly there in the Article 19 and 21 of Indian Constitution. So when there is conflict between two provisions, normally courts will follow the practice of doctrine of harmonious construction, okay? So for example, if you have remembered, in case sometimes we will have issues like for example, what I can say is privilege of parliament members, okay? At that point of time, what happens if they have exercised their freedom of speech and expression in the parliament? Sometimes if there is a parliamentary breach of parliamentary privilege, that means within the house, all walls of the house, anything said cannot be produced as it is except without the permission of the house, right? That means if any newspaper has given exact replica of the speech or something which is made by the member of parliament in the house, the same thing cannot be produced on the papers except with the permission of the speaker or the house. That in that situation, what will be there? In case if any newspaper has said that this person has performed this or he has spoken like this, then it is violation between 105 parliamentary privilege is getting violated, and that editor will claim that 19 year I have freedom of speech and expression. No, at this point of time, both are also constitutional provisions only. Okay, so at this time also they will try to interpret in a way of harmonious construction. Harmonious means both have to be maintained. Both have their utility. So you cannot give weightage to one provision and you cannot weaken another provision. So both have to be with minimal damage to both the provisions. Both have to be interpreted. That is what doctrine of harmonious construction, which will be used most of the times by Supreme Court in interpreting two different provisions of the Constitution when they are getting into conflict. Okay, the same thing will happen in this case also, right to information and right to privacy. Okay, so it depends on the case to case basis again. Then another issue we have in the recent times is with respect to this amendment I told you, and with respect to another thing is with respect to political parties. So political parties, whether they have to be brought under right to information or not, is one issue which is there from the long since inception in 2005 onwards. We have this issue whether political parties have to be brought. And second thing which is not included under right to information is judiciary itself. Okay, so judiciary will say it should be very transparent and accountability should be there, but at the same time they are very reluctant to bring judiciary into RTI, right to information. Okay, so these are the two things which since inception it is facing, but in the recent times CIC's decision to include political parties under RTI, okay, so that has been upheld by the Supreme Court. So now even political parties are also under the ambit of right to information. So previously, Chief Information Commissioner has issued an order that even political parties also will be under the ambit. Okay, so why political parties are reluctant? They say that it will lead to what will happen if political parties will be brought. Vendetta politics will be there. That is what they mostly say. Okay, that means even ruling party and opposition both will argue that it is against their principles, because so in case if they know the information about the particular candidate or the party, then it may be used by another party to target them, and it may result in harassment and all these type of things. No, that is why they don't want, and they said political party itself not a public authority. That is the first thing they highlighted. Okay, if they are not public authority, then what is the job they are doing here? Yes or no? They are serving the public interest, they are doing for the public, that means they are also under the ambit of public authorities, right? So now even political parties are also brought. That is one another thing you have to keep in mind, right? Then what are the benefits, you tell me, of Right to Information Act? Why should we have such act? Transparency, accountability. Then awareness. Okay, it is empowering citizens of India. Then transparency, accountability. Then okay, it reduces corruption and red tape, is a more bureaucratic nexus, anything. Okay, good. Then in case if a mains question is asked, whether do we require Right to Information Act in practice actually, then what you should say? You have to substantiate, no? You cannot say that right to information should not be there. So what you will write at that point of time? Yes. So democracy means you have to write this, no? Democracy means information. Not only democracy means of the people, by the people and for the people, no? So for the people and by the people, of the people also. These three things have to be upheld. That means citizens, they have to know the information, not only they're electing the persons, but from the persons who they have elected, they have to know how they're functioning, everything, no? So if you can quote this type of things. Thomas Jefferson, a political theorist, okay? So he made a statement that information is the currency of democracy. So you can start with these type of statements, okay? In case if you come across, you can quote these type of things. So information itself is the currency of democracy. So that is highlighting the importance of information. So not only this, it also involves citizens in the decision making process, and also it is empowering political participation of the people in the democratic setup, no? Okay, in this way you can write some advantages. Then what are the disadvantages, or like what are the challenges that Right to Information Act is facing in the recent times? Are we able to fully functionalize this particular institution of information commissions and all? Narrow scope. Vacancies are there, lot of things, because in the recent times so many information commissioners and their chiefs in the central level or state level, there are so many times vacancies are there, right? And one another thing you can write in the criticism, or one thing which is stopping this act from fully functioning is, in the recent times, if you have remembered, in CIC's election, this person will be chosen by a select committee, right? In that, who are the members? You have Prime Minister, Leader of Opposition, and one Union Cabinet Minister recommended by the Prime Minister. So just on the ground that there is no Leader of Opposition, government has stalled this process of appointing CIC for so many years. So this has also been observed by the Supreme Court, that list Leader of Opposition or these things, okay? So when you are, see, this is also one point they have raised when this political parties have to be brought or not under the public authority domain. At that time, Supreme Court said, you are including leader of opposition in the selection committee. That means political party person only, no, he is not the part of the government, right? When political party person is involved in the process of selection, how can you reject that they won't come under public authority? That is one the statement used by Supreme Court in this particular issue also. In that way, you can write as many challenges or as many issues if you raise in different dimensions, it will add validity to your answers and all. Okay, in that way, you have to not only broaden the scope of the answer, raise multi issues. Okay, don't stick to only one issue or generalized issues. Try to go into deep in these type of issues where you know in governance and transparency and accountability also you can quote these type of things, right? Okay, and what is another thing? What are the challenges we have further? Yes, so whistleblower protection is not there sometimes in case, okay, in some situations if there is any corruption or any misgovernance happening, at that time if any person wants to leak that information also, okay, so there is no proper protection. So many persons are fear of losing their jobs or employment, all these things, okay, attack on so many whistleblowers. So this is also not there in India. Then you can see here, this we have seen, right, 19(1)(a), speech and expression we have. Then you can see recently Supreme Court observed that electoral bond schemes anonymity is violating the voters' right to access to the crucial information. In this context, this right to information is already implicit. Breach of the voters' right. So in case if it is undisclosed, okay, the donor's identity, you know, that is the main criticism, right, why electoral bonds was challenged, right? Donor's anonymity is there. That is why Supreme Court said it is clear violation in case if it is undisclosed. So what is the reaffirmation made is Supreme Court, the main two pillars on which this RTI is functioning is transparency and accountability. So the court said these two things are not observed or not practiced as part of this electoral bond scheme. That is why they made it unconstitutional. And what did government say in Supreme Court is, Supreme Court, they said that if we disclose the identity of the donor, then it cannot be, like, you cannot justify this earthing of the black money and all. That is why they wanted to keep the donor's identity secret. But I didn't understand what is a justification from the side of the government. Okay, so how it is related to unearthing of black money and donors' identity if it is revealed, right? So again, this was also rejected by the Supreme Court that donors' identity revealing is having no connection with unearthing of the black money from this electoral bond scheme, right? Then evaluation of this RTI Act. Okay, we have seen. So first time it was implemented in Maharashtra in 2005. Okay, if you can remember. Then challenges, if you see in the recent times, unpreparedness of the system and increased demand. So everyone, they're trying to exercise their right to information. So much demand is there, but manpower is also not the same level. Okay, that is why we are facing this shortage of personnel, and it is also resulting in repetitive questions and personal vendetta politics, right? Then what is this landmark decision that was made in 2013 is to bring this political parties under the ambit of RTI Act. Okay, this is one recent landmark decision taken by Chief Information Commissioner to bring the political parties. So these are the issues you can see in the recent times. Vacancies and pendency of cases are there. So this is main thing. Defunct state information commissions. So many states are not even appointing information commissioners and chief information commissioners at the state level. Headless information commission. Head means chief persons are not there, okay, to take care about the organization. Long waiting time for hearing, okay, so they're not disclosing the information within the stipulated time. So this is with respect to Right to Information Act. Any doubts you have with respect to electoral bonds or right to information? Second thing is, we are going to discuss this rights of forest dwellers in India, okay. So this issue always is appearing in news in different contexts. First thing you have to know is, who are forest dwellers? Who are forest dwellers? Who reside in the forest, right? Yes or no? That means they may belong to scheduled tribes or they may not also. Okay, some communities who are not belonging to STs but they're traditionally living in the forest areas, they also will be considered as forest dwellers. So here we have a specific act called Forest Rights Act, which is brought in 2006, or we also call Scheduled Tribes and Other Traditional Forest Dwellers Protection of Rights Act 2006. Same act, okay, but different names you call. So here two persons are addressed by this: STs who are living in forest land and other traditional forest dwellers. Okay, So these two persons and their rights. Why this is in news? Because recently, if you have remembered, Chhattisgarh became, this is not the context I am explaining, context is different, but in the previous thing which you have to remember from prelims perspective is, Chhattisgarh became the first state to grant this right of forest dwellers officially, okay, they have given this protection to the forest dwellers, enforcing this Forest Rights Act, okay. What is the main purpose is, sometimes for forest, any reason for whatever the developmental purpose we want, what we focus is on the forest, right? We wanted to divert as many forest land, as much as a forest land we can, and we try to incorporate those developmental projects without even environmental impact assessments, right? That is what happening. That means it is becoming a threat not only to the environment but also to the communities and their existence. So in this context, in 2006 only, Parliament has brought this particular act, Forest Rights Act, okay. So what will be done through this act means the recognizing the rights of the people who are based on the forest. For example, scheduled tribes and other dwellers. Means how you will assess these persons means, if you stay for one day, then you won't become forest dweller. Okay. So government has identified, because this act was brought in 2006, no? Okay. Till 2005, means cutoff period was set like Citizenship Amendment Act. They said before 13th December 2005, any community, ST or traditional forest dwellers, if they are living for 3 generations, okay, continuously on the forest land, and if they show the proof, okay, that they have been there and they have been cultivating the forest land there, then they will be given land rights or use rights over that particular land, okay. In this way, 2006 Act has given 4 types of rights. We will see what are those 4 types of rights. But main thing what happened is, Chhattisgarh has given recognition to these forest rights. Means that because there more tribal people are there in the central India, so they have given in favor of tribals. But now what happened is, Tamil Nadu government, it has reserve forest will be there. No, reserve forest means you have very reserved rights will be there. That means grazing, everything will not be easily allowed, right, except with the permission of authorities. There they have designated some reserve forest as the wildlife sanctuary, okay. So what happens if they are designating this as a wildlife sanctuary again? There will be further restrictions placed, no? So these people who are living in the reserve forest, they are losing their rights over cultivation or collecting the forest produce or community rights or conservation rights. So that is why they have raised their apprehensions with respect to this particular decision. In this context also, this issue is in news. If you have remembered 2-3 years back also, so many states, okay, so previously they didn't implement the provisions of the act and they didn't give title rights to the dwellers and all. That is why Supreme Court said that every state has to start this process of recognition of forest dwellers. At that time only, UPSC has given an prelims based question also. FRA is implemented by which ministry? Tribal ministry, environment, like this they have given some statements, okay. So it was so much in use since 2-3 years onwards. So main thing is, here you have to remember 4 types of rights will be given for these people. One is land rights. Land rights means, as I told you, they have to show that from 3 generations, okay, they are residing on the same land or the forest land for almost 3 generations. Then they will be given ownership rights of how much? 4 hectares. 4 hectares ownership will be given to those communities if they prove that they are living on the same land for 3 generations. 4 hectares means 10 acres, okay. So that means this land will be registered and they will be given title rights. Title, land titles, okay, that will be given in their name. No new addition will be given. Means in case, see, normally if you have come across this or no, I don't know, but in land laws, SC, STs, okay, STs especially in the reserve forests and these areas, they cannot transfer the ownership of their land, or they cannot gift, or they cannot even give it to the lease, and all these things are prohibited, because again that will be leading to the vulnerability of STs. Most of the times influential people, they'll try to like you can say appease them, or they try to influence them and they can grab the land. That is why this changing or shifting of the land, or you can say there won't be any name change also allowed. In case if you are gifting the land also, it is not allowed. Transfer of ownership is not allowed from ST to non-ST. ST to ST it is allowed. Okay, so this is one provision we have. So here what happens is 4 hectares will be registered under their name, but no new addition will be given and no new land will be added to this. This is the first right they have given. Then second right is use rights. Use rights means, normally these forest dwellers or STs, they will be deciding what are the livelihood options they have. either cultivation or hunter gathering. Gathering means any forest produce, minor forest produce or anything. You know what is minor forest produce, right? Except what is minor forest produce? Like all these things, no medicines and all. So except this timber and bamboo, if whatever the things you collect from the forest and you can sell it in the market, okay, for livelihood, it is considered as minor forest produce. So over those also they are given use rights, means they can collect the minor forest produce and they can sell in the market. And you know, in the recent times we have this Pradhan Mantri Vandan Yojana. Yes, have you remembered this? So that is also brought to realize this particular right only. So they are given Vandan, means whatever the material you have collected from the forest, that can be sold in the market and that can become the income for these communities. Vandan Yojana. So it is implemented by TriFed. Have you remembered TriFed? Tribal Marketing Federation. So marketing of forest produce, that is a main job of this organization. In this context you have to remember. So use rights with respect to minor forest produce. Then you have community rights. Community rights means this is individual right, okay. First one is individual right, second is also individual right. Then you have third one is community right. Community right means as a community you can graze particular land or you can use any natural resources like water bodies present in the area and all. In that way you have the community rights over the forest. Then fourth right you have is conservation rights. That means not only these rights, but you also have a right to conserve the environment, because you know traditionally STs will be connected with nature. Okay, they try to protect the nature and they have so much of nature worship and all these things. So as part of it, they also have a right to conserve the nature also. Apart from this, even in case of any rehabilitation or you know displacement, they are entitled to rehabilitation also. You know, most of the times, because forest land when it is getting diverted, okay, at that point of time they have this right to rehabilitation also. Okay, this is also there under community right only. In conservation right, these type of 4 rights were given under this act, Forest Rights Act. Okay, now why this means, when this particular area is demarcated as wildlife sanctuary, you know, it will curtail, or you can say it will curtail the rights of these persons. No, they cannot easily graze the land or they cannot cultivate. So there will be some restrictions and everything they have to take care, or they have to take permissions from the forest authorities. For this reason, they are opposing this move of the Tamil Nadu government. Okay, clear? So you should know normally a difference between wildlife sanctuary and a national park. What is national park and wildlife sanctuary? Which is larger in area? National park. Then I'll rephrase my question. Among Biosphere Reserve, National Park and Wildlife Sanctuary, which one is larger? Biosphere Reserve, because 2-3 national parks or wildlife sanctuaries can be part of one biosphere reserve, right? Then national park, wildlife sanctuary, what is the difference? Wild animals only you are thinking, but wild plants also will be there.
Because there are also some endangered plant species.
Only they will be considered in, like you conserved in the national park, you are saying. In which there will be more restrictions. National park, very good. Compared to wildlife sanctuaries, national parks will have total prohibition. Okay. So there won't be any grazing rights and cultivation rights, even with respect to research also you will not be easily allowed. But in wildlife sanctuary, these are permitted, not prohibited, permitted with some restrictions. This is one basic difference you need to know. And in national parks can be designated to conserve one particular species also. For example, if any species is at risk of extinction, then to conserve that also we can designate an area as national park. But wildlife sanctuary, it doesn't only deal with one species, but in a broader way, if you wanted to conserve, then you can demarcate it as a wildlife sanctuary. In this way, the basic difference you need to know, right? So both have to be notified, or who will say this is going to be national park, or who will decide who this is going to be a wildlife sanctuary? Who have this authority? Ministry of Environment. To designate a national park or wildlife sanctuary, who will have the authority? Yes. State governments can notify, but before notification, they have to inform to the Ministry of Environment. They have to give clearances after observing. Okay, so then only state government, it is the state government's choice to designate an area as national park or wildlife sanctuary. So this is a basic thing you have to know. Okay, then So here we are going to discuss about this nation wildlife sanctuary also, as it is in news, we don't know. UPSC can ask. So this is between Satyamangalam Tiger Reserve of Tamil Nadu, Malamahadeshwar Wildlife Sanctuary, and also Kaveri Sanctuary of Karnataka. So you know, again, UPSC already have asked one question on the Satyamangalam Tiger Reserve. They have given 4 options, and which of these is at the connection point between Eastern Ghats and Western Ghats. That is why when you're coming across one sanctuary or national park, you need to know the location also. Just type the name in Google and just observe on the map. That is only one thing you have to do. Because if you don't know the location and if you are just hearing the name and leaving it there and then it won't be serving the purpose, right? If there is any uniqueness associated with it, you have to know. Any particular species is famous in that particular area, you have to know. Again, any water body is passing, you need to know. Okay, these are the basic questions only they're asking, but we are just confining ourselves to what is mentioned in the newspaper or in the books. We are not going beyond it. UPSC is expecting that has to be done from the aspirant side. Okay, this is always at the meeting end of Western Ghats and Eastern Ghats, Satyamangalam Tiger Reserve in Tamil Nadu, and these 2 in the Karnataka. So you know, this is forming part of Nilgiri Elephant Reserve, right? How many elephant reserves are there in India? Recently, new one was notified. You have to update, right? Tiger reserves, elephant reserves, when new things are sanctioned. Yes. No. We didn't have 40. Yes, how many elephant reserves are there? How many tiger reserves are there? Recent one? Kaval. Kaval is not the recent one. State government. It did not be notified by the central government, right? It is just a proposal in the state here. We have 54 tiger reserves and 35th elephant reserve was recently notified. Okay? I'm not going to reveal the names. That is your homework. You have to do from your side. Okay? I don't allow spoon feeding. Okay? Check that after class. The latest elephant reserve and tiger reserve. Okay? Then, here you can see this is one of the tiger corridor notified by NTCA. Okay? National Tiger Conservation Authority. It is not a tiger reserve but tiger corridor. Corridor means, you know, between 2 national parks or sanctuaries, they'll place some corridor so that, like, you know, when you're allowing the road or vehicles, okay, so that animals will not have any disturbance. Separate corridors will be demarcated, eco corridors or green corridors also will say, so that this movement of animals will not get disturbed by the movement of humans, okay. In this way, it is a tiger corridor notified by this National Tiger Conservation Authority, which is implementing this Project Tiger, you know, okay. This is a statutory body established under Wildlife Protection Act 1972, okay. It was established in 2006 after recommendations of Tiger Task Force, and this is an agency which will notify the tiger reserves, okay, Project Tiger. Then, so here you see, this is this particular sanctuary which was demarcated. It is drained by Pala River, okay. This is in Tamil Nadu, and you can see this issue, cultural and historical significance, because tribal people, okay, they have this more connection with the land. That is why they started this issue. Potential rights infringement, that is one main objection they have raised. Potential rights means, as I told you, FRA is giving them rights, no, under this act. FRA is also called, as I told you, Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Acts. In short, we call this as Forest Rights Act, okay. So these rights which are guaranteed under FRA, we have seen 4 types of rights, no, those are getting violated in case if this is demarcated as a wildlife sanctuary. That is one concern they have raised. Then, these are the things I told you. Genesis I told you, since it was brought in 2006, enforcement from 2007. About it you can see here. Occupied for generations. So minor forest produce I told you already. Here you can see the title type of rights you can see. Title rights or land rights you can see. Maximum 4 hectares will be registered on their name if they show that they are living for 3 generations. Then use rights with respect to minor forest produce. Individual forest rights also I have given here only. Then community rights to protect and regenerate the forest and all. Relief and developmental rights in case of any developmental displacement, they have to get rehabilitation relief. Forest management rights I already told you, okay. So to protect in forest and wildlife. In this way, basically 4 types of rights are there with the forest communities. If you want, just write down the title rights or these at least the titles if you remember, fine. You can expand on it. Since independence and before independence also, you know, these communities are subject to different things of displacement and all, no? Because Britishers also tried to invade into their forests because of timber and other forest produce. So from then, if you have remembered, all tribal revolts majorly centered over this issue only, right? Because they don't want outsiders entry, because they're losing their culture, their lifestyle, societal changes were brought, advent of Christian missionaries into this. This is one reason, right, why most of the tribal revolts were fought. So from then, you can write any answer. If it is asked, you can just mention a line in this way, so that you are showing that you are having idea about even pre-independence related issues. Okay. Then key provisions is, one main provision which is strengthening this act is empowering Gram Sabha. Okay. So with respect to this, any decision, even if you want to say which is minor forest produce and which is not minor forest produce, every decision will be taken by Gram Sabha. Gram Sabha means the lowest level body. No, you are not giving this. That means this is a democratic decentralization. You are giving the decision making level to the Gram Sabha itself with respect to this FRA. This is one main provision. Then grazing rights, I told you, these are community rights. Everything they have to require the consent of the total community. Gram Sabha means again who will be there part of Gram Sabha? All the adult members who are there within that area of the village or gram, no? So all those persons, they have to give their consent. In claiming the title to the land also, you can say legal title will be given only when they have this proof that they are living for particular area or land for 3 generations. Then only they will be given. Eligibility criteria means, you can see, must be a scheduled tribe. Okay, they must be a scheduled tribe, or they can even qualify as other traditional forest dweller. Okay, so then you can have this rights in 3 generations you have to prove prior to 13th December 2005. This is a cut-off date they have fixed. Before this, 3 generations if you show, that means almost 75 years you have to trace back. Then they should prove that they are living there for bona fide livelihood, means in good faith. Okay, so you are living there in good faith means you are not there to disrupt the ecosystem, or you are not there to exploit the forest. You have to show that in good belief or in good faith only we are living in the forest and we are maintaining this livelihood. In case if you prove these things, then you will be given rights under this FRA. Okay. Then concerns associated is, these are the issues. This is also a potential mains question. Poor recognition. So in spite of giving these type of rights, but still state governments have to recognize these rights, but they're showing the reluctance, because again, development versus environment, all the time this will be an issue, right? So on the other side, there are developmental needs for projects and all, but at the same time you need to conserve environment. So because of this reason, there is poor recognition. Uncertainty in eligibility. Okay, so some people, if they cannot prove before, although they're living there but they cannot prove, and in what situation, then uncertainty will be there with respect to eligibility. Misuse also, some people, they're taking the rights and they're giving leasing rights and all these things to others unofficially for mining purposes and all. So this is also getting misused. Unsustainability of forest resources. So in the recent times, you're seeing more and more forest resources are getting polluted and unsustainably used. So in that way, this act is not going to protect this forest resource. Negligence by government authorities, mainly is bureaucratic nexus. Okay, so bureaucrats are not empowering this act of Gram Sabha. Okay, they are involving politically and they're causing some troubles in implementation. Then imposition of absurd digital process. In tribal areas there will be low literacy. That is one feature we have seen in the previous class also. Very low literacy is there in the STs. Then in case if you are asking to show that the digital proofs have to be given, or in case if you go with the digital process only, then you can recognize your rights. Then how it will become a cumbersome process for them to register and to show the proof and all. So this absurd digital process of imposing and to get or to grant the land rights is also causing some troubles in implementation of this act. Then uneven implementation across the states. As I told you, Chhattisgarh has given the rights, then Tamil Nadu is taking the rights. So in this way, there are uneven implementations in different states. So you can see Maharashtra, Odisha, Chhattisgarh. So these are the only states to recognize these rights substantially. Do remember these states, okay? So you can write in answer, or even if they ask in prelims, you can write Maharashtra, Odisha and Chhattisgarh. Only Maharashtra has enabled their activation to denationalize this minor forest produce, at least in the scheduled areas, resulting in at least 1,000 villages managing their own forest. Means minor forest produce, they can take under their choice, okay? They can have their rights over this in a well protected way that is given by Maharashtra. So do remember these facts from prelims. Then the issue of flow test. You might have come across this, right? We are seeing yesterday also there is a floor test. Yes. Yesterday there is a resolution on motion introduced in Delhi Assembly claiming that they have confidence in the House. There is confidence motion was introduced in Delhi Assembly. If you have come across, Arvind Kejriwal has initiated motion of confidence in the Assembly of Delhi. So in this way, we are hearing about this floor test. Previously, Nitish Kumar has introduced this floor test, and many other things we are observing in the recent times. So what is the concept of floor test means? It is a mechanism to prove whether the government is having majority or not in the House. Okay, so it can be used to introduce no confidence motion, or it can be even used to show the confidence in the House. Two ways it can be used. No confidence, opposition parties will initiate. Confidence motion has to be introduced by the government itself. Okay, in this way, two ways floor test will be conducted. But who is authorized to conduct this floor test, and is there any constitutional backup? Means yes, there is some constitutional backup. Okay, so who is authorized means in case if the assembly is in session, okay, or the House is in session, at that point of time, speaker can initiate the floor test proceedings. Or in case if the House is not in session, then governor can initiate this concept of floor test. Okay, floor test means he can ask the government to show the majority. Okay, then under what provisions means, you know, there is one provision 164 when governor can ask the persons to show their majority on the floor of the House. That is what we call as floor test, right? Here what is more important is it is also called trust vote. Floor test is nothing but trust vote on the floor of the House. That is what the part we use. And you can see here it is held in legislative bodies to find out whether the government is having majority or lost majority. This is done through voting. So different types of votings are there again. No need to remember that. But here, as I told you, House in session, Speaker will have. House is not in session. Then under 163, Governor is having the power to call houses for session, power to summon. Under that power only, this floor test can also be summoned. So 174, Governor can summon. Again, that summoning power is also on the aid and advice of the Council of Ministers at a time and place. Any time, any place. It need not be in the assembly only. Any other place also can be chosen by the governor to sit and discuss. So then 174 clause 2 A is saying that governor from time to time can prorogue the House. 2B is saying it can dissolve the assembly also, governor. Okay, so prorogation, summoning, dissolving the assembly, all these are the things vested with the governor. Adjournment signed die will be with the speaker. Yes or no? Adjourning the House, adjourning signed die means without specifying the date of further sitting if the House is called off. Okay, at that point of time it is urgent signed die we call. That is with the speaker or the presiding officer. Summoning, prorogue and dissolving the lower house will be with the governor of the state. Okay, these are the things you have to know. Then 163, you know, all these powers will be done on the aid and advice. But dissolution of the House, in case if the House lost majority with the government, then it can happen on the governor's discretion. We have discussed in other class, right? Okay, two types of situations are there when the chief minister himself will advise the governor to dissolve. As I told you previously, KCR has asked previous term, okay, when he fought elections in 2018, at that time before 6 months only he went for elections. Then he asked the governor to dissolve the House prior to 6 months only. At that time, on the CM's advice also he can do that. But in another situation, in case of a floor test, if the House has shown that they have lost majority in the government, at that time it is not it is the discretion of the governor, but not on the aid and advice of the Council of Ministers. Okay, this is situational discretion vested with the governor of the state. Then you can also remember that this is a discretion, as I told you, in case if we lost the majority of the House. Floor test in this particular case of Shivraj Singh Chauhan, who was the former Chief Minister of Madhya Pradesh. At that time, the speaker's powers were upheld by the Supreme Court that on the prima facie view, that means on the face, if it is appearing that government has lost majority, then speaker is having the powers. Okay, so he can convene immediately the floor test, or he can give the chance to introduce such type of no confidence motion. That is what observed in Shivraj Singh Chauhan case in 2020 by the Supreme Court. So you know what happens during a floor test. Vote of confidence can be introduced, vote of no confidence can be introduced. Okay, two different things. Here they will ask for confidence. So the government will normally present this, and you do remember For these type of things, not necessarily all the house members need to be present. Whoever are present and who are showing their willingness to vote, only those persons can vote. That means in the present and voting only it will be taken majority. Okay, so not all members are required again. So here CMs will move, as in the case of Delhi we have seen vote of confidence, you can say. Majority members, if they vote in favor, government can survive, otherwise they have to resign. Okay, this is one situation. Voting methods: by voice vote, ayes and noes, by voting through electronic means they can also show, and also ballot box in a different way, but it is again the discretion of the presiding officer on whichever the method he can choose. It happens both in parliament and states, do remember. Okay, don't think that this happens only in state, in the central level also it happens. And composite floor test is one another variant we have. Composite floor test means when two or more parties claim that they are having the majority. So suppose for example if there is hung assembly, okay, so at that point of time there is another discussion with the governor and president, no? So if no party is having clear cut majority, then president and governor can call any party which he thinks that they have majority. Okay, at that point of time he can initially ask them to form the government, and he can give some time like 1 week or something, and he can ask them to show the majority in the house later on. If they couldn't show majority, they have to resign. Okay, later on if they resign and some other party is also claiming and 2-3 parties claiming that they have majority, at that time to show all their claims, okay, then composite floor test will be conducted. Means when 2 or more are asking for majority. Okay, then if majority is not clear, again special session will be convened then after composite majority. Okay, so to see who have majority, present and voting will be done. Speaker also, he'll have casting vote only in case of tie. Okay, in normal situations in floor test, speaker doesn't vote, because if he is voting in the first instance, that will show that he is showing his political alliance. That is why in the first instance itself speaker will not vote. Only in case of tie he will enjoy his casting vote. This is what one feature. Okay, simply they can ask this type statement. Okay, do remember this from prelims. And then next thing we are going to discuss is preamble issue. Why preamble is in use? Why it is in use? Recently Supreme Court agreed to examine, so some people have petitioned before Supreme Court saying that here there is date of adoption, that is 26th day of November 1949, no, but here 2 words were added later on, no, sovereign and socialist. They were added in 1976 with 42nd amendment, right? So when they made changes in 1976, and here the date itself is suggesting 26th day of November 1949. So this is not correct. So at that time it is not reflecting socialist and secular principles, no. That is why Supreme Court said whether they need to remove these 2 things, okay, to enforce this particular date, or whether this has to be changed or something. Okay, date with respect to that Supreme Court agreed that we are going to examine. In this context preamble is in use. Okay, so here decoding is very important. We the people means entirely. Okay, who is most powerful in India? The people of India. Next is the constitution. Okay, so we the people means power is with the people of India. Then these are the things which reflect the objectives of the constitution, right? Objectives means sovereign. Sovereign means we have complete independence with respect to our matters. Okay, so we are completely free and we are not under any country's rule for taking our decisions independently. Then socialist, this is a word which was added, right? Socialist was added in 1946, okay, sorry 1976 with 42nd amendment. So what is the socialism we are following? Democratic socialism, Gandhian socialism, okay, mixed type of economy. That is what we are following. Then you have secular. Secular means positive secularism, which is different from Western secularism, right? That is a negative secularism we call. So what is secularism? Secularism means when the state doesn't have any official religion of its own, it has to treat all the religions equally. Okay, they should not show any discrimination in terms of religion. That is what we call secular state. And democratic means when the representatives are elected by the people directly or indirectly, we call it a democratic state. In India, we are an indirect democracy. We are not a direct democracy. What are the principles of direct democracy? Yes. Hmm. Referendum, plebiscite. Then recall. Then okay. So these are the four tools which are part of direct democracy. Referendum means with respect to a decision, political decision, okay? So yes and no will be asked and people can decide. Plebiscite means previous class also I told you, with respect to geographical things, okay? So whether there should be addition of territory or you can secede a territory, part of the country, then plebiscite will be there. Recall means you can recall the people's representatives if you are not happy with their performance, who are elected by the people themselves. Then initiation means if you think that there is a need for a law which has to be introduced in the parliament, okay, but it was not introduced in the legislature, then you can initiate also. That means here all the things are done from the people themselves, not by the representatives, right? But in India we cannot do these things, right? Yes or no? So India is not a direct democracy. India is following indirect democracy where we are giving all the powers to the representatives and they are doing on behalf of the people. Okay. Direct democracy is followed in countries like Switzerland. They have direct democracy but we don't have. Okay. This is democratic. Republic means head of the state is elected. He can be elected directly or indirectly again. Direct election in case of USA, indirect election in case of India. We don't elect president directly, no. Who is electing the president of India? Electoral college composing of, yes, Delhi and Puducherry. Nominated members will participate in the impeachment of the president, but they don't participate in the election of the president. Okay, so you have to be thorough with these things. Then these are the objectives which the constitution wants to say. Okay, if you have remembered, we consider this preamble as the identity card of the constitution because it is reflecting what the constitution is, what type of constitution we are following. And here we have, these are all the nature of the constitution. For example, justice. Justice in terms of social, economic, political justice. Okay. Social justice means without any discrimination. Economic justice means equal pay for equal work, adequate means of livelihood, proper standard of living, nutrition, everything you can see. And political justice means everyone, under republic there is another provision most of the people will also ignore is all public offices in India are open to all. There is no discrimination, right? Anyone can contest as president of India if they have at time 35 years of age and if they are citizen of India, right? That means there is no restriction. That is also one political justice principle only, okay? Then we have liberty in thought, belief, faith, expression and worship. In all these things we have liberty. Liberty means freedom, okay? Then equality. Equality of status and opportunity. In both the things we should have opportunities. Then fraternity means maintaining brotherhood, unifying as India, okay? So in maintaining individual dignity and also unity and integrity of the nation, this is fraternity. So you know which is also added here, unity and integrity, this principle along with socialist and secular. These were added subsequently in 42nd amendment. That means preamble can be amended, but only one amendment was made so far. Okay, do remember this. So next, you know, in our Constituent Assembly, this is the date of adoption. Date of enforcement is different. Okay, date of enforcement is 26 January 1950. Okay, on that day we enforce the provisions of the Constitution along with preamble. And you know, preamble is based on what? Objective resolution introduced by Jawaharlal Nehru in 1946, no? Okay, so this became the basic thing on which our preamble was drafted. Objective resolution introduced by Nehru. You know, after enacting all the provisions of the Constitution, then they have enacted the preamble. We have taken this concept of preamble from which country? US. Okay, US preamble is there. So from there we have inspired and we have taken this provision. And then significance means you can write, okay, it reflects the objectives of the Constitution as well as nature of Indian polity. In that way you can write the importance of what is the true spirit. Then We'll discuss the main things here. You can see this is a context. Okay, so Supreme Court agreed to examine socialist and secular, although they were added in 1976 without altering the date, whether it is valid or not. Okay, so that will be the thing. Preamble means, you know, introductory statement. Just it is like a preface to a book. Okay, you will get some idea before reading the book. No, same way preamble also inspired from US, I told you, and object is resolution of Jawaharlal Nehru. Date of adoption is different, date of enactment is different. 26 November 1949, 26 January 1950. These two are different. Do remember this. Then what is the significance? I told you already. Okay, so then content we have seen. Interpretative value is one thing which Supreme Court said, means although preamble, okay, it is like a preface, but still it can be used in interpreting in case if any question is involved with respect to fundamental rights, directive principles or any other provisions, then preamble can be interpreted by the Supreme Courts or judiciary in understanding what can be done in that particular case. That means they have interpretative value with respect to preamble. That means it can serve like a guiding principle for deciding the cases related to these things. Then amendments made, I told you. Only one amendment was made in 42nd Amendment in 1976. Okay, preamble can be amended. Do remember. Then cases associated is one where you have to remember, right? First case is Berubari Union case, right? You have in 1960s we have no Berubari Union case. So what is that case with respect to exchanging of a land territory? Berubari is a place in West Bengal. Okay, what happened is, you know, when India and Pakistan got bifurcated, Radcliffe Commission has demarcated the boundary, right? West Bengal is having at that time boundary with East Bengal, that is Pakistan, present day Bangladesh. No, at that point of time, what happened is initially they didn't object anything, but later on they started claiming and they're asking for Berubari. Okay, so at that point of time in 1948. Nehru and Noon is one person from Pakistan president. So they have signed an agreement, Nehru-Noon agreement we call in 1948. It was signed between these two persons. They have made an understanding that 12 parts, exchanges we call, okay. So that will be exchanged horizontally, means if there are 12 areas in Berubari, territory of Berubari, 6 will be exchanged, means Pakistan, it will give surrounding area, and India, whatever they ask, they will be exchanged. So this is the issue that is happening at that point of time. But Parliament has raised objection because till then we didn't give any part of land to other country, no. But what did government say? We are not giving any land. Intake, we are also taking some land, no. Okay, that is just an exchange. There is nothing cession of land to another country. So that doesn't require any parliamentary approval. That is what the stand of the government is. At that time, opposition in Parliament said no. As you are exchanging land also, that should involve approval from the Parliament. Then what happened? It was referred to the President of India. What should be done? President has exercised his powers under Article 143, that is advisory jurisdiction, and he asked the Supreme Court's opinion. Okay, at that time, first time Supreme Court said preamble. Why this preamble is linked to this issue means, as a sovereign state, the government said, as we are a sovereign, we are free to take our decisions. That means we can exchange the land. As the government, we have the power, we have the majority, we can take the power to exchange the land. So it doesn't require parliamentary approval. Then this issue of sovereign in the preamble also came to picture. At that time, what did Supreme Court say? Preamble itself is not the part of the constitution. Then how you can take power from the preamble and how you can say that we are having power. Okay. In this case, for the first time, Supreme Court said preamble is not the part of Indian constitution. But later on, you know, subsequently, in Keshwananda Bharti case, it has overruled its own decision and it said preamble is the part of Indian constitution. Later on in LIC case also, it was reiterated that it was part of constitution. That means even today also we are having the same provision, that is preamble will be considered as part of the constitution only. Okay, that means it can be amended. If it is not, okay, if it is not part of the constitution, then what happens? Parliament doesn't have power to amend the preamble, right? Okay, that is what first ruled in Berubari case, but later on it was changed, right? Clear? Any doubts? Then MSP. Okay, you know why MSP is in news? Because farmers have launched again their protest, second protest, you can say, second wave of protests in Delhi, asking mainly for this MSP. Okay, so what is MSP? You know, minimum support price. Why it was guaranteed by the Indian government? Because in case of any distress sale, okay, farmers have to be provided with some minimum support. Okay, that means in case if there is a huge production of one particular crop, in like it got flooded, the particular crop is flooding the market, then there won't be price for that particular crop, no. Or in case if there is any loss of the crop, then also no one will try to purchase. And in that situations, in these two situations, government will purchase a crop from the farmers at some support price. That means they'll not be at loss. The farmers will not be at loss. To support them, this minimum support price is given. But if you have to date back the origins of minimum support price, first time we have this Food Grain Inquiry Committee, which was constituted by then Jawaharlal Nehru cabinet, but they didn't follow the recommendations. At that time also they said there should be some minimum support price, but this was not implemented subsequently. Later on again, Lal Bahadur Shastri, when he was the Prime Minister, okay, you know, he is a person also who have given the slogan Jai Jawan Jai Kisan. Okay, he's so much concerned about the farmers and the agriculture. So at that point of time, he constituted a committee called LK Jha Committee. So this committee said there should be a minimum support price type of mechanism. So first MSP was announced in 1967 following the recommendations of this LK Jha committee. Okay, just mention this committee in case if a question is asked in mains. Okay, then you know, as it was just based on the recommendations of a committee, it is a policy decision. At that time, they did not bring any law in the parliament to give this backing to the MSP. That is why even in the recent protests also, if you see, the main demand is they're asking the legal backing for MSP. That means a statute has to be brought so that it will have legality. Okay, in case if MSP is not implemented in the future, okay, then farmers will not have any fear. Because of MSP, you know, 22 crops and the support that is provided by the government, so many farmers are going for cultivation in these 22 or 23 crops, no. So in case if future governments change this provision, then what will happen? That is why the farmers are asking for legal backing, okay, in the recent times. So this, you know, initially this MSP, when it started in 1967, it was recommended by Agriculture Price Commission. This was later renamed as CACP, Commission for Agriculture Costs and Prices, in 1985. Okay, so two main things you have to remember is, it is fixed by a commission called, it is determined, what should be the price will be determined by CACP even before the sowing season only. That means not after the crop coming to the market. Okay, before sowing of seeds only, they will determine that for this season this is going to be the MSP. So if you are happy with that MSP, you can go with that crop or you can change the crop. That is what one main provision is there. So this will be determined by CACP, Commission on Agriculture Costs and Prices. Okay. Later on, whatever the price that is determined, that will be finalized by another commission called Cabinet Committee on Economic Affairs. This is Cabinet Committee, you know, okay, which is extra constitutional in nature. There is no mention about cabinet committees in the constitution, right? To ease the functioning of cabinet or to simplify the job of cabinet, we have this cabinet committee on cabinet committees. Okay, how many cabinet committees are there? Only 5. This government has repealed some committees and 2 committees were added. Okay, check out 2 committees which were added recently, and do remember, for only one committee, that is Cabinet Committee on Parliamentary Affairs, Defence Minister will head. Okay, so previously it used to be headed by the Parliamentary Affairs Minister only, but now they have changed that Defence Minister will head this Cabinet Committee on Parliamentary Affairs. Except this committee, all other committees are being headed by the Prime Minister himself. If any Cabinet Committee there will be a Prime Minister as a member, then it will automatically be headed by the Prime Minister. In case if Prime Minister is not a member of any committee, then they'll have separate minister as the head. But only one committee we have in the recent times is Cabinet Committee on Parliamentary Affairs, which is considered as super cabinet. Okay, because most of the political things will be taken care by this Cabinet Committee only. So except this committee, all other committees are headed by the Prime Minister himself. Okay, like you have Cabinet Committee on Security, Cabinet Committee on Accommodation, on Appointments also you have, Political Affairs Committee you have, and we have this Economic Affairs Committee. In the recent times we have, with respect to employment and economy, we have 2 committees formed. Okay, so in that way you have to remember, and they don't have any constitutional backup, do remember. Okay, here what is one main thing you have to remember is, it is form of market intervention. You know, immediately after producing a crop, okay, in case if it doesn't get a better sale, you know, mostly what happens is the farmers will go to the market and they'll try to sell off, the persons who are buying that particular crops, the traders or the middlemen, they'll try to exploit the farmer, no? Okay, so he doesn't have this option of storing the crop anywhere in cold storage, because everyone are not financially affordable to store them in the cold storages, no? Or in case he cannot, the transportation cost also he cannot incur, and he cannot again take back for some other day, he cannot store. That is why he'll try to sell off even if he gets a very what you can say an unacceptable rate, you can say, right? In case if he doesn't get a better rate also, without any other options of storage and other things, he has to sell off the crop. That is what observed in the market. So to prevent this, government what it is doing is, it will buy at MSP. Okay, if you're getting a more than price than MSP, you can sell off. But in case if you're not getting a better crop, then minimum support price will be there. Okay, so who is buying at minimum support price? It is FCI. Okay, Food Corporation of India is there, no? They will purchase the crops and they'll store these particular crops which are brought at MSP in their godowns. From here it will be sent to the PDS. So again from PDS, states will buy and whatever the designated amount they want, that will be bought by the state governments, and through PDS they're distributing to the people. In this way it is operating. So this MSP is a form of market intervention where it is just a policy decision which is not having any legal backing, to ensure the people of agriculture with respect to agriculture produce against any shortfall in prices. Okay, suddenly if after initially when they're sowing, the crop price is very high, but later on if there is decline in the price at the time of selling in the market, then what will be the person's fate, right? So large scale farmers suicides also we are seeing in India because of these things. That is why MSP was given. And also even case of bumper production also, this MSP will be implemented. As I told you, this is a committee which is chaired by the Prime Minister, will be finalizing the rate of MSP. So here you have to remember, this is at the beginning of the sowing season only. But here most importantly, some main things will be considered. Randomly they don't decide the date, prices of MSP. So they will consider some things like, what is the commodities demand and supply in the market, cost of production, market price trends in the domestic and international level, inter-crop price parity. That means if two crops, MSP is the rice and wheat, okay, so how much is the difference, that they will also observe. So now most of the farmers are asking, same price should be given for wheat and rice, so that will not harm another particular commodity. So in the times of deciding MSP, you will be coming across these terms, A2, FL and also C2. We have this type of calculations we will come across, right? A2 means these are the things which the farmers incur. Like for example, if they have to buy fertilizers or if they have to engage labor in cultivation process and all that cost is calculated as A2. Okay. To this cost, if you add family labor, because family labor also will be involved in the agriculture process, right? So their wife or their children or their parents, they also will be involved. That is, if you add this family labor cost to this A2, already acquired cost will be there, no? So in the process of cultivation, then it becomes A2 plus FL, okay? So this is one thing you have. Then you have this C2, this price is what we consider as capital assets price. Means in case if you hire any equipment like tractors and all, if you take anything on rent, that thing will also be added, okay? So these are the terms which you come across. And what did MS-Swaminathan committee recommend? To the cost of production, it should be more than at least 50%, okay? This is what Swaminathan committee, that is National Commission on Farmers, has recommended. For example, if the cost of production is 100 rupees, then 50% of 100 is 50 rupees. Means 150 rupees should be given as MSP. That is what MS Swaminathan has recommended. But in the recent times, if you see, that is not we are calculating, and we are not even guaranteeing that much, 50%, okay? So that this 50% again will be used for next crop inputs, okay? Because they have to buy all these things, no? Initially they have to buy. Later on they're getting MSP. But who will give if you are not, if you're not having money or if you're falling short of credit, right? So you need to get the money in advance. So at least 50% is what promised or recommended by MS Swaminathan, okay? Then the terms of trade between agriculture and non-agriculture with respect to input and farm output prices also. Whatever the things which are used in agriculture and non-agriculture things, farm inputs, those also have to be calculated. Minimum of 50% margin also have to be there over the cost of production. and what are the implications in case if MSP is used, okay, it's implemented, then what will be the impact on the consumers, that also have to be taken care. All these factors have to be taken care by CACP. Then it has to determine that this can be a price of MSP. That will be finalized by CCA, that is Cabinet Committee on Economic Affairs. Then what are the objectives? A guarantee price, I told you, to prevent the farmers from distress sale. So these are the advantages of MSP, you can say. Tell me, what are the advantages? Income security will be provided to the farmers. We'll have food security also. In case if MSP is guaranteed, no farmer will show reluctance to grow any crop which is guaranteed by MSP. No, they'll go without any fear or favor. Then, what are the other advantages you have if MSP is implemented? More profits for the farmers. Buffer stock, okay, buffer stock. Food security only. Then, what are the advantages? Yes? What are the advantages if MSP is implemented? Okay, good. That means crops are not getting diversified. That is one disadvantage, but still, okay. So if you are giving MSP for one particular type of thing, like millets, if you give, okay, so then automatically more farmers will tilt towards growing of or producing this millets type of thing, right? Good. And what else? Middlemen can be eliminated. Okay, so they can have a remunerated fair price, you can say. Good. Fair and reasonable prices can be guaranteed. Then what are disadvantages? Same thing means it is not allowing crop diversification. So MSP means the more people, instead, even if they have options also, they're going only for MSP crops. And yes, and only 22 crops. So now you know rice, and like especially rice, if you see, that is very water intensive. No? If you are giving MSP for such water intensive crops, then our agriculture and agriculture and ecosystem also, it is getting impacted, right? In the future, we may not have sufficient water to fulfill our needs also. So again, it should be diversified, MSP, okay? And there is no uniform. So in everywhere it is having its differences, you can say. Every area cost of production varies, cost of fertilizers vary, cost of labor varies. So but if you are giving uniform MSP, again it becomes a difficult task for the farmers, right? So these are the things. But here, what are the crops covered under MSP means 22 crops are there, and one crop you have is FRP, fair and remunerative price for sugarcane. We don't call MSP for sugarcane, but fair and remunerative price we call. So these are the things which you have to remember. 7 types of cereals. You can see paddy, wheat, maize, bajra, jowar, ragi and barley. Here 5 types of pulses. Chana dal, arhur, tur dal, you can say urad, moong and masoor dal. Then oil seeds, rapeseed, mustard. This is one only. In the mustard, that is why we are using this GM mustard in the recent times, because we are traditionally dependent on imports for oil seeds. Okay, so if we increase this GM mustard, then we can decrease that import dependency. That is one reason stated by the government. Groundnut, soya bean, sunflower, sesame, you have safflower and niger seed. These are the things. Then 4 commercial crops you have: cotton, sugarcane, copra, dried coconut and raw jute. These are the 4 commercial crops. Total 22 here, and 23rd one is sugarcane. Okay, for which this is given. So the UPSC already have asked on which if this MSP will be given. And then in 2022, a committee was constituted by Union government. You know, previously in 2020, farmers have gone for protest. At that time, Prime Minister has repealed, or Parliament has repealed, better word, Parliament has repealed this 3 farm laws we have. No, the same Parliament can enact laws, it can repeal laws also. Okay, at that time, this committee, Prime Minister has made some promises to the farmers that we will look into these issues. At that time, afterwards, they have formed this committee, which is headed by Sanjay Agarwal, okay, who is one of the secretary to the government, Sanjay Agarwal committee. Now the dispute is also with this respect to this committee. Why means, although they have referred the issue of MSP to this committee, but they did not include, the terms of reference of the committee did not include legal backing to the MSP. Means, on what things committee have to make recommendations, okay, in those recommendations there is nothing that they have to examine as whether there should be legal backing to MSP or not. That is why farmers are asking. You have constituted a committee, you are saying that MSP will be looked by that committee, but as there is no legal backing, that is what the committee has to refer, then how you can ensure that there will be legal backing. That is why even the recent protests are also say with respect to the same. Okay, so three things have to be looked. One is MSP, and zero budget natural farming is another issue what the committee will look into, and crop diversification. Okay, so like turning to millets instead of cereals and all. Okay, in the changing climatic patterns and all, it does not include legal guarantee. That is why again they have launched their protest. Okay, then we have another important bill that got passed in 2 houses of parliament is Water Prevention Control of Pollution Amendment Bill 2024. It has to get President's assent. Okay, it is passed by both Lok Sabha and Rajya Sabha. So what is the main provision is, you have previously Water Act passed in 1974. Okay, if you have remembered, first act we have is with respect to environment. What is the first act we have? Wildlife Protection Act, right? Then Water Act in 1974 we have. Then Air Act we have 1981. Then Environmental Protection Act 1986 we have. Okay. In this way, Biological Diversity Act, many acts were later subsequently passed. But main act we have is Water Act, which was passed in 1974. But what is the main issue is, now they have decreased the punishments awarded by 1974 Act, and they have weakened the provisions of that. That means in the name of development, okay, so they have made the stringent provisions very lenient in the recent act. Means government is saying to promote ease of doing business, we are doing this. But at the same time, this may result in increase in the water pollution and other things. No? Now water has become a scarce resource, right? So many countries are facing this issue of water shortage, right? Okay, so if you have remembered Niti Aayog's Composite Water Management Index, what did they say? Almost all the main cities of Hyderabad, like including Hyderabad, they are going to run out of groundwater by 2050 if the current rate is prevailing. Means if there is no artificial recharge of this groundwater, like after rainwater harvesting, all these things, if we don't do, then by 2050 most Indian cities will run out of groundwater. That is what highlighted by Niti Aayog's Composite Water Management Index. And if you have remembered, in South Africa, previously 2 years back or so, there is water emergency also declared. At that point of time, they have faced a severe water shortage. So 1 year we are experiencing floods, 1 year we are experiencing very difficult situations. No, in this context, if these such laws were brought, again weakening the provisions of already made act, then it would worsen the situation. Okay, so this is having very importance in the mains, because always, even with respect to prelims also, you cannot say, because environment also, they'll focus every year on 1 or 2 legislations. They'll ask you what is the provision and what type of powers they have with respect to central government and state government. Such statements are asked every year. 1 or 2 questions are coming from legislations. So this year you have to focus on Water Act, as the bill got passed in the Lok Sabha and Rajya Sabha. So it is getting amended, means it is amending this act. 1974 Act is getting amended. So you can see this is a main act which is responsible for sustainable management of water resources. So what is the main thing? It is addressing certain shortcomings, but at the same time, regulatory frameworks are also getting compromised. We will see what are the amendments proposed. These are the main things you can remember. Decriminalization of minor offences. Means previously in 1974 Act, there are even minor offences are also awarded with huge punishments and penalties, like minimum 25,000 to 2 lakhs fine, and also imprisonment of less than 2 years, 3 years. Punishments are also given for minor offences. But now new act has decriminalized it. Decriminalized means those are not anymore offences now. Okay, that means you are making it more lenient for the people who pollute the water or who will misuse these water resources. This is one provision. Then exemption is given for certain industrial plants, even if they pollute also, okay, or if they make the water level very in a situation where it cannot be feasible for the human consumption also, they have given some exemption. This is also one provision that is provided there in the bill which was introduced on passed. Then enhanced regulatory oversight. They are saying we are exempting, at the same time they said we are enhancing the regulatory oversight so that even water bodies in the water will not get misused or polluted. Okay, in this way they have made some changes. So you just need to remember these 3 main points from mains perspective. you can elaborate. But Water Act, if you have to remember, the same Water Act has created one body called CPCB, if you have remembered, Central Pollution Control Board, right? So it was initially created. If anyone, most of the times will think that it was established under Air Act. No, it was established under Water Act. Subsequently, it was also enforced by the Act provisions of Air Act 1981. Okay, so CPCB is one statutory body you have, right? So what is the main purpose of this Water Act is maintaining and restoring the wholesomeness of the water and preventing the water pollution. So central and state pollution boards were constituted under section 3 and 4 of the Act respectively. It is a statutory body. If you have remembered, they have asked a statement with respect to NGT and CPCB, comparing the bodies. They have given a statement that one is a statutory body and another is a constitutional body. Both are statutory bodies only. NGT is also a statutory body, National Green Tribunal, which was established under National Green Tribunal Act 2010 itself. Okay, what are the acts on which NGT can have power? You know National Green Tribunal, no? On what laws they have power? NGT. Good, okay, Water Act. Because of this only, if you have remembered, when this Shri Shri's Art of Living Foundation, when they conducted that on Yamuna River mines, they have imposed a heavy fine. Crores of rupees they have imposed. No? Water Act. Then Air Act. Then Environmental Protection Act. Then Biological Diversity Act 2002. Then Forest Conservation Act 1980. Then Civil Nuclear Liability Act we have, no? This was passed in 2010. Okay. So over these 6 acts we have, and most important thing is it doesn't have Wildlife Protection Act under its jurisdiction. That is where you get trapped. NGT doesn't have jurisdiction over Wildlife Protection Act 1972, except that major environmental legislations are brought under NGT. Okay, so you know NGT means with respect to environmental issues, it is a tribunal. Okay, for speedy and faster adjudication of environmental disputes. You know NGT runs on a basic principle of natural justice and not CPC. Okay, principles of natural justice is on which this NGT runs. Natural justice means, what is the principle of natural justice? What is the principle of natural justice? See, 2 main principles will be there, part of principles of natural justice. No one can be a judge in his own case. That is first principle. Second one is audi altrum partem, means right to be heard. Okay, so other side of the party also have to be given a chance to be heard. Without hearing the other side, you cannot decide the case. So these are the 2 fundamental principles. In legal language, we call it audi altrum partem. Okay, right to be heard from the other side also. These 2 principles are principles of natural justice. Okay, these are followed by NGT in adjudicating any case, right? Then, so you know CPCB is also entrusted later on with Air Act provisions also. Combinedly it is enforcing Water Act, Air Act, both provisions. That is why, as it is entrusted with Air Act provisions, if you have remembered, National Air Quality Index, okay, it was also released by CPCB only. So how many are listed under AQI? 8 pollutants are there. Yes or no? AQI means color coding of pollution for every city. You will see in Hindu paper also, if you see, colored index will be there, poor, satisfactory, good, bad. If you have observed paper any time cleanly and clearly, then you will find it, AQI index will be given in every city. Okay, so color coding will be given. 8 pollutants are there. What are those 8 pollutants? PM 2.5, PM 10, lead, Pb means lead, you know, no? And ozone, okay. Then carbon monoxide you have, nitrogen dioxide you have, SO2 you have, and one another thing. Yes? Okay. These are the 8 pollutants which are listed by National Air Quality Index. Based on these 8 pollutants, it will give the ranking for the cities in a color coded index. Okay, AQI you have to remember. Then, you know, it functions under Ministry of Environment, that is a basic thing, you know. Along with this, it is enforcing the Water Act provisions. Before we go to another topic, just let me know what are the ways in which water is getting polluted, what are the main sources? Sewage, industrial, then acid rain, okay. Then oil spills, okay. Then eutrophication, that is a phenomenon, right? Point sources and non-point sources, this is what you have to know. Point sources means from the direct sources, non-point means which you cannot trace out, okay. So this is one new basic thing, and you know eutrophication is a concept you have to know from environment perspective, okay. Eutrophication means when there is enrichment of nutrients like nitrogen because of excessive application of fertilizers which contain nitrogen, phosphorus and all, so there will be algal bloom, okay. So that means more algae will bloom. When more algae bloom, what happens? That means, yes, so yes, it will decrease BOD. When it is decreasing, that means less biological oxygen demand is there. That means if more and more algae die, okay, so then oxygen is required by the organisms to decompose, no, so then more oxygen will be used by them to decompose and less oxygen will be available for other marine organisms for their survival. So then it will result in dying of algae, algal bloom we call, okay. That is a main factor, eutrophication, with respect to water pollution also you have to remember. BOD, higher BOD is good or lower BOD is good? Yes, a lake should be having less BOD, that means it is less polluted, okay. BOD, COD difference? Biological oxygen demand is with respect to organic matter, okay. COD means it includes organic and inorganic, both chemical oxygen demand we call, right. Do remember these things. Then what is this? Yes? Okay. Drone, UAV. Okay, the topic we are going to discuss is high altitude pseudo satellite. Why? Because India recently, under CSIR, there is one research agency with respect to space. They have tested, that is NAL, National Aerospace Limited. This is only R&D we have in aerospace. R&D means, you know, research and developing organization, which is under CSIR. Okay, so with respect to aerospace, so they have first time tested this unmanned vehicle. You know, unmanned vehicle means there won't be any pilot. Okay, aerial vehicle means which will fly. So that is what UAV lone oka rakam idi. Idi enduku ante, again I will use English only. So high altitude means it will fly at a higher heights. Okay, pseudo means it appears like a satellite but it is not a satellite. Okay, so it generally appears like a satellite, it will function like a satellite but it is not a typical satellite. That is one thing. So why it is very important and why I have chosen to include this is, as India has successfully tested this, okay, if everything goes well, India will become the 5th country, and okay, only to 4 countries they have till date this technology in terms of pseudo satellites. Okay, so what are those countries? US, UK, China, South Korea. Okay, these are the countries which already have demonstrated this technology of pseudo satellites, high altitude satellite. Okay, so India is going to become the 5th country. So in these type of things, if we became the first time or if we test, UPSC always will focus on these areas, right? That is why I have included this. So from where it has tested is from Karnataka. Okay, you need not remember the name, but just remember the state. Okay, from there we have tested. And do remember CSIR, you know, this is headed by whom? Who will be the head of CSIR? Department head, chairperson or chairman ever. Who will chair CSIR? What is CSIR? Council for Scientific Research in India. Yes, CSIR, right? So it will be headed by Prime Minister. Okay, under which you have so many R&D organizations. Chala unnai, chala different domains. Like if you remember NERI, we have no NEERA. This is with respect to energy efficiency, and you have this NERI is only responsible for green crackers. Recently, India is really using this green crackers, no? Diwali time, you know, green crackers we are using. So that is also developed by this NERI, which is under CSIR. That is one of the R&D organization, okay? Like this particular agency. We have some other R&D organizations, but here we are confined to this aerospace laboratory. So what is the main thing is, so you know, main problem is we are having unmanned vehicles, no? That is not at a higher height. Generally they fly at a very lower height only. But we have satellites which are at the very higher level. But in between this distance, if we want to cover any area, then we don't have anything which is functioning in this domain. That is why we have tested this high altitude pseudo satellites. Normally, you know, aeroplanes will fly in the stratosphere, right? Okay. But you know, these type of satellites generally will be there in the exosphere. You know that layers of atmosphere, right? Troposphere, stratosphere, thermosphere, mesosphere, thermosphere and exosphere. These are the 5 layers of atmosphere we have. So in troposphere only we have this all atmospheric phenomenon happen, and that also supporting our biological life. Above this you don't have this support of biological phenomenon. Stratosphere is where you have ozone, and it is where the flights will fly. Yes or no? Stratosphere. Then you have mesosphere. Mesosphere is where the meteorites, when they burn, that is where from they come on, okay, meteorites. So in mesosphere we have this. So in troposphere and mesosphere, the temperature decreases with height, but in stratosphere, temperature increases with height. Okay, this is what happens in stratosphere. నేను అదే చెప్పాను కదా, troposphere, stratosphere, mesosphere I discussed. నేను తప్పు చెప్పానా? No, I said the same thing. Okay, then you have troposphere, then we have thermosphere. Thermosphere also consists of an ionosphere layer, you know, radioactive ions will be there, and you have exosphere. And another thing is, in mesosphere only we have this International Space Satellite, you have no ISS you have. So ISS will be located in low Earth orbit, no, that is in mesosphere range we have, okay. So then we have exosphere, no, that is where space actually starts, and most of the satellites will be placed in exosphere, okay. So that means in between this range we don't have. Okay, that is why we have demonstrated this technology, so that we can place them between the satellites and UAVs. This range is, this area is unexplored because of lack of technological demonstration. So now we can place these type of satellites here. Here we have satellites, here we have UAVs. So in this region we can cover these things. Same purpose of satellites, whatever they do, like weather forecasting, helps in disaster management, communication, security related purposes, everything only, they also do the same thing, but they're covering a different range. Okay, normally they will be placed at altitude of 20 kilometers from the surface of the earth. Okay, that is a basic thing you need to know. And these are solar powered, so they'll get energy from the solar energy only. So they don't take much cost for satellite launch also, because they're directly in the form of aeroplane or unmanned aerial vehicles only, no. So low cost also will be incurred when we are launching this type of satellites. Okay, this is all the advantage you have. So potential applications, you can see this is one 20-kilometer range aircraft only, very long duration flights. They can stay in the stratosphere and all for almost months also they can stay. Okay, that is one advantage which is offered by this type of satellites. You can see the benefits. It is solar powered, and the missing link between UAVs and also conventional satellites, this particular area will be covered by these type of satellites. Applications, you can see telecommunications, emergency and public safety communications, intelligence, means border areas also you can keep a surveillance using these, and maritime surveillance also will be one advantage. Okay, in this way this is offering the solutions. It can be in the form of aeroplane, airship and balloon also. It need not be in the form of aeroplane only, it can be in any form, and it is solar powered vehicle. Okay, do remember these facts. Clear? Again a area where prelims question can be asked. Environmental monitoring, land border control applications. Compared to ground based, they can cover larger areas with less interference. Okay, from a larger area they can cover easily, helping data transfer easily, and also the cost will be very less, and they don't require launching vehicles every time like satellites, because of which the cost to launch them is very less. Okay, economically also it is viable for us. Clear? Any doubts? Then with respect to India, what is the significance is Hindustan Aero Limited, you know, that is HAL there in Hyderabad itself, if you have remembered. Okay, there is HAL. So here it is testing this futuristic technology in collaboration with a startup company. So it can provide this surveillance over land boundary of 15,000 kilometers and coastline of 7,500 kilometers. If we have this technology, efficient border patrolling, trafficking movements and all these things also can be checked using this satellite. Okay, this is advantage we have. So high definition cameras are there, round clock surveillance, all these are the advantages which they offer to us. Okay, in case if they are implemented. Then UAPA. Okay, in the recent situation, so many activists, okay, or who are jailed under UAPA, they have filed applications before Supreme Court, because UAPA is a specific law which is different from the general law. Because in general criminal law, what will be the consideration means, they'll consider bail is the rule and jail is the exception. Okay, that means most of the criminal laws will consider that bail should be given, that as a rule. Okay, means unless until it is a non-bailable offence only, but most of the situations they'll consider it as a rule, jail is an exception. That is what the principle of general criminal law. But in UAPA it is a specific law. Okay, so which is altering this provision. See, ikkada UAPA lo enti? Jail is an exception, sorry, jail is the rule, bail is an exception. In this way, it is differing with the general criminal law. That is why Supreme Court em cheppindi intaku mundu cases lo ante, in UAPA charged cases, okay, you cannot just give bail immediately. Okay, after prima facie examining the evidences that there is no involvement of that person, then only it will be granted. So here the general criminal law principle is getting deferred. That is why in most of the UAPA cases and arrests, okay, generally bail will not be given easily. This is what they are asking from the Supreme Court. Okay, so many activists have asked for granting bail, and you know, subsequently this UAPA so much, it was also in news. Here, with respect to Khalistan also, one person who was arrested, okay, he was denied bail by Supreme Court in the process of asking this bail. So you know, this was brought in 1967. Okay, so you know, in 1967, why this was brought? What is happening at that point of time? Yes, again this UAPA was mainly brought at that time because they are asking for Khalistan and all. At that time, National Integration Commission, okay, they have recommended that there should be a separate law brought, and 16th amendment to the constitution, okay, they said that there should be some amendment to article 19 clause 2. What is 19 clause 2? Which is imposing reasonable restrictions on freedoms which are provided under 19, no? Yes or no? Okay, so on those grounds, if there is any breach of sovereignty and integrity of India, then a person can also be sentenced to imprisonment under this UAPA. That is what this 16th amendment has recommended through amending this article provisions of 19 clause 2. Okay, so what is UAPA? Unlawful Activities Prevention Act. Okay, so this is a primary law with respect to terror in India. Okay, that means if any person is involving in terror or terrorist related activities, he can be jailed under this provisions of UAPA. So one main thing is you should know the applicability. Applicability means it is not even only applicable to Indians, Indian officers who are stationed abroad also in the capacity of government of India, they also are applicable under this act, and even foreign nationals are also applied under this UAPA. Means if any foreign national has committed, at that time also you can sentence them punishment with this UAPA. Okay, this is the first applicability you should know. Then subsequently there were amendments passed. In 2003 we have an amendment. Then what did we do is we started adding one provision that if any person committed any terrorist act, okay, and till then there is no provision of adding this terrorist act. Means if any person resorted to any act of terror, then that person can also be jailed. Okay, that is one provision we added in 2003 amendment. And we placed a ban on organizations if they resort to any terror practices, and that ban was only limited to 2 years in the beginning, 2003 amendment. Subsequently in 2014 we extended this ban to 5 years. Okay, if a ban is imposed in an organization which is supporting terror acts, it can be banned for 5 years in functioning. Okay, that is one provision we made in 2014. But you know, again in 2019 it was more strengthened, right? Yes or no? What is the reason is because till previously we have in 1966 only terror organizations can be designated by the central government that they are promoting terror, but there is no provision of designating any individual person as a terror like who is sponsoring terror as the person banned under UAPA. So in 2019 amendment only, first major change we made is we started labeling individuals also as sponsoring terror organizations in case, and we are also we can sentence them to the punishments under UAPA. That means we have included the provision of individual designation also. Previously we have only organizations that can be designated. And second provision we made is, you know, what is a terror organization in India? We have anti-terror organization, NIA, right? National Investigation Agency, right? So this NIA is having the powers, and it should frame the charge sheet within 90 days only. Okay, from the date of occurrence of the particular crime, within 90 days they have to file. Maximum 180 days time will be given. That is one provision. That means we have kept timelines also, because these type of cases involve a lot of sensitivity, you know, so they should not get postponed and they should not be delayed. That is one provision added in 19. Then Director General of this NIA, he can ask for he can issue orders for search and seizure of any property in case if it is associated with terror. Okay, then he can issue some orders, and he can even give powers to search and seize that property also. That was also added under 2019 amendment. Okay, so here what is the most thing you have to remember is UAPA is criticized most of the reasons because it has given absolute power with the central government only. That is the main reason for criticism. So most of the powers are given only for the central government. Okay, and in the recent times, you know, this UAPA, although there are so many cases getting filed under UAPA, but the conviction is very low in terms of UAPA. That is why so many people are criticizing that whoever doesn't like whoever are challenging the government or who are criticizing the government are getting sentenced under UAPA. That is one criticism that this is facing in the recent times. Okay, in this way you have to know this is different because here jail is the rule, bail is the exception. But in normal cases, bail is the rule, jail is the exception. Okay, in this way it is a specific criminal law, right? Okay, here you can see it is outlining and penalizing unlawful and terrorist activities. What are the activities on which they can be punished? Means aiding and abetting terrorists, and you can see funding terrorism, inciting anti-national feelings among the masses. So anything which you cause, which is impacting sovereignty and integrity of India, then you can be sentenced under UAPA. Okay, then key provisions, as I told you, wide-ranging powers with the central government. So previously 1967 only organizations can be designated as terrorist organizations. 19 amendment made, even individuals also can be demarcated as organizations, terrorist organizations. Applicability I told you, both Indians outside, inside India and foreign nationals are also applicable. And I told you timeline, maximum 180 days, but within 90 days investigation has to be completed. Okay, charge sheet means 180 days. Special courts can also be formed with respect to UAPA cases, and you can see 2019 amendment, as I told you, it has been amended in 2004, 18, 13, 19. 19 amendment is recent and most important. It has increased its scope, you can see here. So what is the scope? I told you, even including these individuals as terrorists on the same grounds. And approval of search and seizure, I told you, Director General can order for search and seizure. Insertion of some schedule of treaties. So in case if you are doing these acts, anything related to these things like taking persons as hostage or smuggling related things, okay, all these things will be designated as terrorist acts. Okay, they have widened the scope of terrorist acts. And even if you know, not only the things but any economic offences, for example smuggling, counterfeit currency, all these things are also considered as terrorist acts only, okay, under this new 2019 amendment. And section 43D of this UAPA is saying granting of bail is virtually impossible under UAPA. That is why bail is most of the times denied under UAPA for most of the people who are sentenced, okay. But what is the main thing is prima facie should be there. Prima facie means on the face of view of the particular case, it should appear that that person has to be granted bail, okay. Then only they can be given. So you can see Union of India versus K.A. Nazeeb case in 2021, where Supreme Court said granting of bail under UAPA when the accused has undergone incarceration is a significant period. That means only when that is proven that a person has undergone for long without any valid reasons, then only a bail can be given. That is what Supreme Court has opined. Bail under UAP was an exception, jail is the rule, okay. Then we are going to discuss about prelims topics, hardly 10 minutes, you just wait, okay. So conservation of migratory species. So this is one environmental convention we have, that is Bonn Convention, if you have remembered, okay. So migratory species means they migrate from one place to another place when there is a change in weather pattern, right, okay. So during winters, to escape the extreme winters, they migrate from one place to another place. Like you have Central Asian flyway which is passing through India, like the East Asian flyway, Africa Asia flyway, like this we have some things, no. So this is one convention which is also called Bonn Convention, which is dealing with migratory species, okay. And in terms of environment, this is having its unique place because this is the only environmental treaty which is covering all types of terrestrial, aerial, avian species. Terrestrial means land based, aerial air, avian means in water also, okay. So all these species are covered under this, you know, because for aquatic, for example, if you have remembered, olive ridley turtles are there, no. So those are not native to India, no, okay. So they are coming all the way from Pacific and Atlantic oceans and the breeding here. Even in aquatic also, they migrate from one place to place for breeding grounds or some other reasons, okay. So in this way, these are the migratory species which are covered under this Bonn Convention, and you can see 14th COP, Conference of Parties to this convention, is going to be held in Uzbekistan from 12th to 17th February, okay. This is one recent thing which is happening in Samarkand. You remember 2022 SCO summit also happened in Samarkand, okay, in Uzbekistan. So you have to know this is another name is Bonn Convention. It was signed under the aegis of UNEP. You know, UNEP is the Environmental Division of United Nations. And when was it formed? It was formed in the same year 1972, where Stockholm Conference was held for the first time. UN Conference on Human and Development. In the same year, same conference, UNEP was born, and we also decided that 5th June will be celebrated as Environmental Day. These are the two main outcomes apart from environmental things, okay. So UNEP will give a major award, is called, what is it called? Major award given by UNEP for best conservation of environment, which even our Prime Minister has won. Champions of Earth Award, okay. Our Prime Minister also was given with this awarded with this award. And if you have seen in the recent times, one woman from India, Purnima Devi Burman, okay, so she was also awarded with this Champions of Earth Award, right. Then, so here you can see this is with respect to conservation and sustainable use of migratory animals as well as their habitat. This is headquartered in Bonn, Germany. It was signed in 1979. So only global and UN based intergovernmental organization like treaty exclusively covering, I told you, terrestrial, aquatic and avian species. Two appendices are there. One is dealing with migratory species and second is dealing with unfavorable conservation status, okay. In case if anything is not, okay, for example, because so in one place it may have one status in conservation, that is in terms of IUCN. In one country it can be designated as critically endangered. But if it is coming here and breeding here, there may be high population here, no. So because of this, there can be differences in conservation status. At that time, it will be dealt under Appendix 2, okay. This is one provision. Then we have PM-SVANidhi, okay. So this is one government scheme which was recently introduced in the wake of COVID-19, right, for street vendors. Yes or no? Street vendors, when because of COVID-19 and they have lost their employment, right? At that time, how much? 10,000 rupees will be provided as collateral free loan. Collateral means, you know, a guarantee or security which you have to show, okay, to get a loan. So without any collateral, you will be given 10,000 rupees for street vendors, okay. So why this is recently news is because recently they have collected the data and they have observed how many beneficiaries are getting and is it the scheme actually benefiting the persons or not. So it was launched in 2020. You have to remember the ministry, as I told you, Ministry of Housing and Urban Affairs, okay. And it is a microcredit facility. You have to remember collateral free loan. Here they can trap you, and with low rates of interest. It is not interest free, mostly below 12% will be charged for 1 year period. And what is the long term objective? To improve the credit score of the vendor. And you can see digital record also will be maintained, okay, how many persons and what is the socio-economic status of the vendors we can know. In this way they can get formalized, you know, because street vendors are informal economy, no. So in that way, if they take loans and all, we may know how many persons are there in the informal sector and they can have formalized data. The need for the scheme is they should not go to the money lenders or private lenders, okay. We have to increase more institutional mechanism. So financial inclusion, you can say COVID-19, in the wake of COVID-19 to support them economically, this was released. So all vendors who are having a certificate of vending, they are eligible under this, not everyone, okay. So the certificate of vending is given by this act, Street Vendors Act 2014, where there will be some persons, town vending committees will be there, authorities and town vendors will be there from that area. They'll issue the certificate of vending. Who have the certificate, they're eligible to get the benefits of PM-SVANidhi, okay. Then we have section 125 of CRPC. So you know this is famous because of Shah Banu case, right? So we have the Shah Banu case in the recent context of Uniform Civil Code also. This case is famous, right? See, section 125 of CRPC is giving maintenance rights to the concerned persons, okay. Who are entitled to maintenance means wife, children, parents of that person, okay. Means here what happens is there are some conditions also, who can get and who cannot get, okay. So main thing is the every religious law, for example Hindu Marriage Act you have. So section 24 of Hindu Marriage Act has a provision for maintenance. At the same time we have a separate act also which is called Hindu Adoption and Maintenance Act, HAMA Act we call. That is another act we have for Hindu law in terms of maintenance. We have Special Marriage Act, no, section 36 of Special Marriage Act. It also deals with this provision of maintenance. But what happens is, even though if we have these many provisions, and in Shariat law or Muslim law also we have a provision of maintenance where a Muslim man has to give maintenance for divorced wife in only for 3 months period, that we call as iddat period, okay. Iddat period means the 3 menstrual cycles of the woman, okay. So when she undergoes 3 menstrual cycles, till that period only he has to pay her maintenance. That is what mainly challenged in Shah Banu case. What is the reason is that woman was divorced after 40 years of marriage, Shah Banu, okay, by her husband. Then he said only for iddat period, that is 3 menstrual cycles only, she is entitled to maintenance. You know, after 40 years of marriage, if only for 3 months if you give maintenance, that is only for 90 days, okay. So that is not sufficient. That is what she went to the Supreme Court saying that, okay. At that time Supreme Court said under section 125 of CRPC that woman is entitled to maintenance not only to 90 days, but it should be more. So whether it is unlimited or not means again there is some condition there, okay. In case that person if he gets second marriage, okay, then she cannot get more than that particular period. That means a divorced wife, until that husband gets remarried, till then she can get maintenance. That is one observation made by the Supreme Court. And second provision is, for example, if that woman has divorced on the mutual grounds, then she is not entitled to maintenance. And another provision is, for example, if that man is not having financial affordability to give maintenance, then what is the situation, right? So then also Supreme Court said it is the absolute right of the woman to claim maintenance even if the man is unemployed. Because on this ground, most of the people, they're saying that we are getting, like we are unemployed, so I cannot claim maintenance, I cannot pay maintenance, okay. So they just, to avoid maintenance, they can say that I'm unemployed now, and they're losing their, even they're leaving their jobs also. So this is what observed in the trend. That is why Supreme Court said this is absolute right. Even if he is unemployed, he has to pay maintenance. but that maintenance proportion, the amount will be determined based on that financial ability of that person. It is not uniform, okay. They'll ascertain the position of the person, income and everything, then they'll determine the maintenance. So whether the woman only entitled means wife is entitled, children are entitled, parents are also entitled. So parents means the mother side, the father side, okay, the divorced person side. So their parents, that means boys' parents are also entitled. And the children means here the Supreme Court said whether it is legitimate children or illegitimate children, both, because Supreme Court already said a statement that even out of an illegal relationship also, the children born are considered as legitimate because they don't have anything with this illegitimacy, So every child will be considered as legitimate only. That is what Supreme Court said. So here you have to remember whether illegitimate or legitimate, children also have their right to maintenance until unless they have their own earning abilities, means of a certain age. And if after a certain age also, if they're suffering from any medical issues, then also that father has to pay maintenance to the children. Okay, in this way there is a thing. But at the time when Supreme Court said no, Shaban was entitled under section 125 of CRPC, then Rajiv Gandhi government has brought a law, because that time huge protests started because this is a clear intervention in religious laws, because we don't have a uniform civil code, So Muslims started raising protests saying that this is a intervention by Supreme Court in religious domain, so we are not accepting. At that time, Rajiv Gandhi government has enacted a law called Muslim Women Protection of Rights Act in 1986, reversing the judgment of the Supreme Court, said that only for 90 days period maintenance can be paid. Okay, that was done as a political stunt again at that time. So when this happened, now the issue is the same. So many times the maintenance is the same. So here also recently Supreme Court, okay, so it agreed to examine whether a divorced Muslim woman can claim maintenance or not. Most important things you have to remember is maintenance of these three things, okay, wives, children and parents, both are there. Financial support has to be provided from the husband side. So who can claim, as I told you? Wife should show, okay, it is not random that every wife has to be given, but they have to show that I am unable to maintain myself. Means if she is unemployed and she cannot maintain her livelihood, at that time only she can be granted maintenance. Then you can see legitimate or illegitimate children, as I told you. Then parents also you can see equally by son and daughter, both mother and father, and by son and daughter, okay, they have to be maintained. So adoptive mother and this adoptive father, they also will be included under this ambit of maintenance. This is one interesting thing. And what are the conditions that has to be met? Means the person should refuse that I am not going to pay maintenance. Then only they can approach to the courts under the section 125 of CRPC. Okay. Initially they should neglect or refuse to pay maintenance. Dependency is one. That means they must establish that they are unable to earn themselves or unable to maintain themselves. Then you can see sufficient means also should be provided. So that person, whoever is have to pay this maintenance, that person also have to show, okay, what are the means through which he is earning and all. Quantum of maintenance, court will determine. It is not equal, okay, how much should be paid, and the capacity, it will be depending on the capacity and in a reasonable and fair amount. This is one you have to remember. Duration, it can be given monthly basis, temporary or permanent, okay, until unless the court decides. So enforcement, as I told you, it doesn't comply with the court's order, then he can be sentenced to jail also. Defaulter may face legal consequences, okay, in case if he fail to provide maintenance. But one main thing is, wife cannot claim maintenance under three situations. If she is living in adultery, you know what is adultery, right? Okay, if a married man has relationship with another woman who is not his wife, okay, then we call it as adultery. This is under section 497 of IPC, which was initially criminalized but later decriminalized by Supreme Court. Okay, it is no more an offence. It was decriminalized on two grounds, because it is not gender neutral. You know what is adultery, right? You don't know? No or okay, fine. So here consider A, B, C, D, okay. These are two couples, right? Here female you have, this is male, female and male, okay. So main provision is, in case if these two get into relationship, okay, B and C, these are not married to each other but they got into relationship, then you know this woman cannot file a case against this woman, okay. So under the grounds of adultery, that she is having extramarital relationship with my husband, but this man can have or can file a case against this man saying that he is having extramarital relationship with this wife, my wife, okay. So this is one provision that is there under adultery. So as this woman is not empowered and this man is empowered, so it is one law which is not gender neutral, okay. And second observation made by Supreme Court is, here the consent of the woman is there. That means husband is treating his wife as his own, okay. That means this particular woman's individual autonomy to body and all these things are not considered. That is what Supreme Court said. So as she is going consensual, okay, this is not an offence. On these two grounds, Supreme Court has made it decriminalized, okay, section 497. So when it is adultery means when this wife who is claiming maintenance, if she is in extramarital relationship, then she cannot ask for maintenance from the husband. Then if she refused to live with the husband without any reason, okay, if she is only started separating and she is living separately without any valid reason, then also she cannot claim maintenance, and they are living separately by mutual consent, okay. So if they have resorted to mutual divorce, okay, then also in these three situations she cannot claim maintenance from the husband. Yes. Then we have another concept called biodiversity heritage sites. Even if you want to leave also, I don't leave you, because sir has given me full freedom. He asked me till, even I can extend my class till 2 o'clock, but I'm not extending, I'll complete in a while, okay. So today, as you don't have another class immediately, so you will have your lunch break between 2 and 3, okay, don't worry. What? You have to write a test. Okay. So you have biodiversity heritage site. Recently, Odisha government has designated one place as its 4th biodiversity heritage site. So what is this biodiversity heritage site? Means a place where there will be rich biodiversity, okay, which is having rich endemic species, native species, or you can say keystone species, and there is species richness. In these type of criteria, we can designate as one place as biodiversity heritage site. That means you can better conserve the biodiversity there. So under which act it is having its pass? Means Biodiversity Act of 2002. This was signed and this was nationally drafted because of CBD. You know, under CBD, Convention on Biological Diversity, when we have signed this in 1992, India has to ratify that in the Parliament of India, right? That is why under Article 267, if you have remembered, okay, so international laws have to be ratified in the Parliament to give effect in the domestic level. So under the same capacity, under Biodiversity Act 2002, this biodiversity heritage sites were declared, okay. So you have to remember, Odisha's government 4th biodiversity site. How many biodiversity sites are there in India? Means 36 are already there in different states. For example, if you have remembered, Majuli Island, have you known about it? Majuli Island, the only riverine island in India. It is created by Brahmaputra river. Majuli, it is only the district, Assam, riverine district you have, no? Okay. Riverine island means island created by river, Brahmaputra river, okay. That is also a biodiversity heritage site. For example, I am giving you. And in Telangana, only one biodiversity heritage site is there, that is Aminpur Lake. You know Aminpur Lake, where it is located? Sangareddy district you have, okay. Only one biodiversity heritage site from Telangana. And one important thing is, why I am discussing with respect to Telangana is, it is the only first water body which is designated as biodiversity heritage site. First water body to be recognized as biodiversity heritage site in India, Aminpur Lake, and also first one to be recognized in the urban area. Yes, Aminpur Lake. Because of these two specialities, Aminpur Lake is also important. As you belong to Telangana and we are residing here, just I am giving you this information. Okay. So in what type of areas? Means ecologically fragile ecosystems, this will be designated. Species richness, endemism, and also rare endemic species, keystone species, you know. Okay, I told you already what is keystone. So keystone means supporting pillar type of thing for that ecosystem. So the same thing. So who can declare? Means state government. In official gazette they can notify in consultation with local bodies, okay, to conserve this biodiversity. State governments are even empowered to frame schemes for conservation. They can consult with the central government to frame the rules, how they can be managed with respect to this. Means this is very important area where questions can be asked. It is the state government who is empowered to designate an area as biodiversity heritage site. So what is the importance is, better conservation, and in case of any loss of biodiversity also, we can restrict the human presence, then we can conserve. So then you have retail inflation. So this concept, you know why it is in use, because for the first time in the recent 3 months you can say, retail inflation, that is CPI inflation, has reached a low of almost 5.1% recently. Okay, so you should know what is inflation. Inflation means increase in prices, right? So what is deflation then? Reduction in prices. What is disinflation then? Very good. When the inflation is going at a slow rate, that you call disinflation. Okay, inflation is there but it is continuing at a slow growth rate, then you call disinflation. Okay, so these are the things you need to know. So inflation in India we have in two terms, two indices we have, no, WPI and CPI. So this is, what is WPI? Wholesale price index and consumer price index. Wholesale means at the wholesale level, that means at the first production stage only, if you are measuring the change in price level, that you call WPI. But when you're when you're counting the inflation or price rise at the consumer level, the final level where you consume, okay, that is what CPI we have. Okay, so now previously we used to take this WPI into consideration, but now we are considering CPI as the basic thing. Okay, so in monitoring the inflation, so RBI will be considering CPI based inflation only when it is targeting the monetary policy, through monetary policy, right? So here you have to know retail inflation means it is also called CPI. Retail inflation or CPI is same. So it is based on fixed basket of goods and services. For this you have to know what are the differences between WPI and CPI. So it is calculated only for goods. Here goods and services both will be considered under CPI. Wholesale level, consumer level, okay, first level and second level. This is with respect to base year 2011-12. This is base year 2012. Okay, this is released by, yes, Department for Promotion of Internal Trade and Internal Trade also, and we have under Ministry of Commerce. Okay, this is Ministry of Commerce. This is under NSO, National Statistical Organization, under MOSPI, Ministry of Statistics and Program Implementation. Okay, so this is a basic thing you have to know. So under the CPI inflation only, we have kept a target that RBI 2 plus or minus 4%, means 2 to 6% range only it should be there. That is what inflation targeted by RBI. Okay, so this is the basic thing you need to know. So CPI, what does it tell you? The cost of living, the purchasing power, expensiveness of articles in relation to others, and value of the Indian rupee. Okay, so if there is more inflation, then our rupee will be very strong or weak? Weak, no? Okay, so too much inflation is not good and very low inflation is also not good. It should be in an ideal way, that is 2 to 6% what observed by RBI. Okay, so it was even extended, this target of 2016 we have this monetary policy, from this to 21 we have kept this target for 5 years, 2 plus or 4 minus this plus or minus 4%. This was even extended till 2026, means till 2026 we'll have this same 2 plus or minus 4% targeted inflation only by RBI. Okay, means it should be not less than 2%, not more than 6%. In that range it should be there, inflation, to be good for the economy. Okay, in CPI, yes, plus or minus means 4 minus 2, 2%, 4 plus 2, 6%. Okay, so anyway, 2 plus or అంటే నెగటివ్ లో రాదు కానీ but still we write 2 plus or minus 4%. Okay, so that is the one basic thing you need to know. And in CPI we have different types of inflations again. CPI urban, CPI rural you have. CPI combined. CPI combined is taken for monetary policy consideration. And apart from this we have CPI agriculture, labor, rural labor we have, and CPI for industrial workers also we have. These two are released by Labour Bureau under Ministry of Labour and Employment. And first two, CPI rural and urban, this will be taken care by, combined will be taken care by NSO. Okay, this is one basic thing you need to know. As I told you, base year is 2012, NSO will take care about this, and combined. Okay, so combined inflation will be taken. So this is what you have to know. Inflation targeting, price stability and deflator. Okay, value of salaries, wages, pensions, everything will be determined based on the level of CPI inflation only. Then Kalsa-Bhanduri project is one thing which is in news. Okay, this is a dispute between Karnataka and Goa. Okay, so why this is in news? Because Kalsa and Banduri, these are the tributaries of Mandovi river. You know Mandovi river? Mahadayi river we call, no? Mahadayi or Mandovi river, this is in Goa. Okay, so this is, so they wanted to divert the water from this river to Karnataka. So Karnataka, to fulfill its drinking water demands, because Karnataka is a state with very less water scarce state. Okay, so to fulfill its demands, it wants the water from Goa. That should be diverted from Mahadayi river or Mandovi river. But will Goa agree? No. So again, this is a dispute. Already proposed, but it is again a dispute now. Why this is in news? Because recently National Board for Wildlife, okay, this is again a statutory body constituted under Wildlife Protection Act 1972. Okay, for what purposes? If there is any diversion or if you want to change boundaries of any national park, wildlife sanctuary, you have to get approval from National Board for Wildlife. It is headed by the Prime Minister of India, not the Ministry of Environment. Okay, do remember this. National Board for Wildlife has to give permissions if it has to be diverted. Any area of national park or wildlife sanctuary has to be diverted. Okay, they didn't give approval for diverting the forest land from this Kali and Sahyadri tiger reserves. These are two in Karnataka. From this particular project, for diverting this, they didn't allow. Okay, so again, you have to remember when you're coming across Wildlife Protection Act, what are all the bodies constituted under it? National Board for Wildlife we have seen. I told you previously, National Tiger Conservation Authority we have discussed, and there is another body also constituted. What is it? Under Wildlife Protection Act. Yes? What is another statutory body constituted under Wildlife Protection Act? Yes? No? గుర్తు రావట్లేదు. No? You are not strong in the environment? No? That is what I observed. For everything which I ask in environment, you don't answer. Okay. But you should make them as strong areas, right? Focus. As you are appearing for 2024, you should focus. Check that also as part of homework. What are all statutory bodies constituted under Wildlife Protection Act? These are the easy areas where you have to score. Don't ignore. Then this project involves construction of dams and canals to divert the water from Mahadayi river or Mandovi river, which is based in Goa, to the Malprabha river. You know Malprabha is the tributary of which river? Krishna river. Okay. Ghatprabha, Malprabha, these are the two tributaries of Krishna river. You have Musi river, which is a tributary of Hyderabad. Musi is a tributary of what? Which river? Musi is a tributary of which river? Krishna only, no? No? Inta confusion. Here itself you have Musi. Huh? Where is Krishna river having its origin? Mahabaleshwar or Triambakeshwar? Mahabaleshwar in Maharashtra, right? Go through these tributaries also, very important. Easy areas, if you leave, I cannot help. Then drinking water is the main thing which is asked by Karnataka to, for this project. Okay, so this has already created a dispute between Karnataka, Goa and Maharashtra because drainage system. Okay, again. So these two, Kalsa and Banduri, these two are the tributaries of Mahadayi river or Mandovi river. Okay. Then you can see origins, this river, Mandovi river is having its origins in Western Ghats in Karnataka. You can see it travels 35 kilometers in Karnataka, 82 kilometers in Goa, and it meets Arabian Sea. That means it is a west flowing river. Okay, it meets Arabian Sea at Panaji, capital of Goa. It is also called Mandovi in Goa, Mahadayi in, and it is a rain-fed river. Okay, so mostly southwest monsoon is feeding this river, and Salim Ali Bird Sanctuary is there in this particular. And you can see here these are the tributaries. No need to remember everything. Just remember this Kalsa and Banduri because it is in news. Okay. Next topic is Supreme Court Collegium. Why it is in news? Because recently, Supreme Court has quashed an order given by Andhra Pradesh High Court ex-Chief Justice, you can say. Previously, when they were Chief Justice, they made a statement that they were transferred only on the recommendations, or like because they have given a verdict against the Chief Minister of Andhra Pradesh, they were transferred. So they have given an apex order cancelling this Supreme Court's Collegium's recommendations. In that context, this is in news. So you have to know quickly, you know, there is no mention about Collegium in the Constitution of India, right? So this is a judicial invention with respect to appointments and transfers of judges in Supreme Court and High Court, okay? So how we have this is because in Article 124 and 217 of Indian Constitution, they said appointment of judges will be done by the President of India. But there is no clear mention on what grounds it will be done. So it has resulted in some disputes. You know, 3 judges case, we have this collegium system, right? First judges case we call SP Gupta versus Union of India case, where this Supreme Court, what did it observe is, the President is appointing the judges, but he has to take the advice of the Chief Justice of India, means consultation or concurrence. It revolves around these 2 words only. First judges case, they said they have to consult. Consult means they can ask your opinion, but that opinion, if it is not mandatory on this person, then it is not the case. No? That is what observed in. That means consultation can be done with the CJ in case of appointment. In second judge's case, this collegium system was born. Okay, they said consultation not only means just consulting, but concurrence also should be there. Means whatever the advice that is given by Chief Justice, that has to be followed by the President of India in appointing the judges to Supreme Court and High Court. Second judge's case, we have collegium. But collegium means what? Again, they have defined that Chief Justice of India, along with 2 senior most Supreme Court judges, he will determine who have to be recommended to the Supreme Court and High Courts. Only 1+2 is in second judge's case. In third judge's case, they expanded this collegium to 1+4 senior most judges, what is that we are practicing in the recent times. Okay, in this way we have 3 judges case, and you have 4 judges case also, you know, where this NJAC was quashed by the Supreme Court. That is 4th judges case, but you know, that was totally cancelled off by the Supreme Court, no, because of executive's interference in the judiciary, as it is saying that it is a violation of independence of judiciary. It was nullified by the Supreme Court. So 3 judges case you have to know with respect to collegium. 2 words are very important: consultation and concurrence. In first judges case, only consultation. Second and third, I said consultation means concurrence. Okay, in what situations they have to be consulted means, except CJ's appointment, because whoever is the senior most among the judges, he will become the CJ. Except CJ's appointment, in all other judges appointment, CJ has to consult his collegium, 1+4. And in appointing the judges and transferring judges of High Court judges also, this system has to be followed. That is what Supreme Court has given. Okay, it is not mentioned in the Constitution, is where you have to focus upon. As I have given here, you can see this PDF will be shared. First judge's case 1982, second judge's case, this is Advocates on Record versus Supreme Court. This case, second case where they said consultation means concurrence. Okay, this is what second is expanded to CJ must consult and it should be in writing. For example, out of 1+4, okay, in case if they deviate, okay, then majority view will be taken. And if more than 2 judges object to that recommendation, then CJ should not recommend that to the government. Among the 5, 1+4, if more than 2 persons are not happy with the recommendation what is proposed, that this person has to be appointed or transferred, then that should not be recommended to the government. Okay, what is the role of executive in this system means, after judiciary sending the names that this person has to be elevated to Supreme Court or transferred to the High Court or appointed, then executive just has a role. It can just ask the Supreme Court again to re-examine or reconsider. But if second time it is asked again, same name is reiterated by Supreme Court, means government has to finalize that name. It has to follow. Then another thing is, only Intelligence Bureau will examine the particular records of that person. That's it. That is the only role of the executive in this process of appointment. Okay, this is what already there here. You can see executive's role I told you already. Okay, so same thing is that you can read after the class. Then we have Swami Dayanand Saraswati. Why I have mentioned is, recently his 200th birth anniversary was celebrated. So when these things happen, 100, 200th anniversaries, or if some specific event happened, then you should focus in terms of history. They can ask any related question to this person. So you know, he is also called, what is his actual name? Dayanand Saraswati. Yes. What is his actual name? He is associated with which organization? Arya Samaj. Okay. Established in 1875 in Lahore. Okay. Later he shifted to Mumbai. Okay. So he born in Gujarat and he's a social reformer, you know, responsible for this Arya Samaj. Mainly, what are the things he said is idolatry, rejection, ritualism. He didn't focus on idolatry worship and ritualism. Shuddhi movement, you know, okay. Again, converting those who have converted into Hinduism. Go back to Vedas because he considers these Vedas as the authentic source and infallible. Then women's rights are also advocated. Then you can see ban on child marriage and all. In this also you can quote in the recent context where increase in the age. No? So educational reforms, you know, Dayanand Anglo-Vedic schools, DAV schools were established, and literary work is Satyadra Prakash. This is a book he authored, okay, along with Veda Bhashya, Bhumika and Veda Bhashya. So you know this Arya Patrika is also edited by him, which is reflecting his thoughts. This is the information about him. Then we have Pradhan Mantri Surya Ghar Muft Bijli Yojana. Okay, you know, this is also in lines of Pradhan Mantri Suryodaya Yojana only. This scheme is launched mainly to provide 300 units free electricity power to like every month to 1 crore households. Okay, to save the current bill and all. So almost 75,000 crores is the investment. You just remember this number also because they can change it. So heavily concessional bank loans will be given and a national online portal will be linked so that the persons can get. So rooftop, you can generate your own electricity, save your current bill and you can sell off the extra thing so that more income, less power bills and employment generation also happens. So this is one of the main thing implemented by Ministry of New and Renewable Energy. Okay. Last thing is you just have to remember, okay, almost this free electricity supplying the, and also in terms of this electric vehicles also, you need not go to the points. You can charge your own vehicles at your home only. Entrepreneurship will be there, employment for the youth and skill upgradation also happens. These are the benefits of the scheme. Okay, so we have last thing. I just want to mention there is no explanation because this Kaji Nemu is designated as a state fruit for the state of Assam. So when these type of things happen, UPSC can just ask you, okay, this is a GI tagged fruit, lemon only, a specific variant in Assam. It was named as its state fruit. Okay, previously UPSC has this trend of asking state butterfly. Recently, which state has did? Okay, so you should know the name of this. Okay, Kaji Nemu means it is a GI tagged fruit from Assam, which is named as its state fruit. Okay, this is just a basic information. Clear? Any doubts you have? No doubts?